Good morning. Welcome to our December session in Philadelphia. The first time, it's a pleasure to be back. Our first argument in Philadelphia in 2 years. Live. Been doing it by Zoom. Been Zooming. Because the opinions, decisions arising from this oral argument will not be completed before January 1st of 2022. Justice Saylor is not sitting. His votes would not be helpful to the court because he can't participate in the ultimate decision. So he made the decision to not sit with us. But he's certainly here in spirit. We all miss him. We will miss him for years to come. As we argue, I will do a quick summary of the case, and there's two purposes for that. First, so those of you who have no idea what's occurring in the case have a very little idea, but also, more importantly, so the council will know at least what I perceive the case to be about, and if I'm wrong, you can correct me and make sure that we're on the right track as we listen to the cases. And with that, again, glad to be here. Brian, will you call the first case?
Commonwealth of Pennsylvania versus Pownall. Representing the Commonwealth, Mr. Matthew Davis. Representing Mr. Pownall, Mr. Charles Gibbs.
The appellee is a former police officer. He's charged with murder and other offenses for a shooting that occurred while he was acting in his capacity as a police officer. Anticipating that the officer would present a peace offer justification defense under subsection 508A of the Crimes Code, the Commonwealth presented a pretrial motion to the trial court arguing that under the United States Supreme Court precedent, that section of the Crimes Code is unconstitutional as written, and the suggested jury charge premised thereon is also fatally flawed. The trial court denied the Commonwealth's motion, finding that the case needed to develop before any rulings could be made. The Commonwealth sought interlocutory appeal. The Superior Court quashed the appeal. We granted allowance of appeal to consider whether the Superior Court improperly quashed the Commonwealth's appeal, and if so, to consider whether we should decide the merits of the Commonwealth's constitutional challenge to the Crimes Code. Now, Mr. Davis, if I got that more or less correct, feel free to argue, and if I did not, feel free to correct me.
Good morning, Mr. Chief Justice, Honorable Justices. May it please the Court, my name is Matt Davis. I'm an Assistant District Attorney at the Philadelphia District Attorney's Office. Your Honor, Mr. Chief Justice, I believe that is largely correct. As you said, the Commonwealth did file an interlocutory appeal in this case from a pretrial order, which, if upheld, would permit Pennsylvania police officers to defend themselves from criminal charges by claiming that they were entitled to use unconstitutionally excessive deadly force. As Your Honor noted, the Superior Court panel below held that it did not have jurisdiction to give adequate attention to this case. The Superior Court... Well, Your Honor... Absolutely. But there are exceptions to that final order, the standard of waiting for a final order, and two of those exceptions apply here. There's the collateral order doctrine under Rule of Appellate Procedure 313D, and then there's also the Commonwealth's right to appeal an interlocutory order where it terminates or substantially handicaps prosecution.
Commonwealth, I apologize. Share with us from the very beginning. The first question granted is about jurisdiction.
Yes.
A jury instruction is only applicable after there's been evidence presented in a trial for which the jury trial instruction could apply. How is it that you believe this matter is right before this court when the case has not begun? Defense has not introduced any evidence whatsoever. Thus, you're asking us to make a decision on a non-case or controversy. I don't see that falling any one of your exceptions. Share with us how you believe it does.
Absolutely, Your Honor. The answer is making an important distinction about what we're asking in this case. And we are not asking that this court or the Superior Court consider whether defendant will be able to offer a defense or whether the facts at trial will support him offering a defense. All this case is about is that defendant indicated in pretrial proceedings that he intends to offer this defense at trial. Taking defendant at his word that he will do so, the Commonwealth is appealing to ask this court to rule that if that defense does come up at trial, if defendant ends up asserting that defense, and if the evidence supports his assertion of that defense, that the jury must be instructed constitutionally when it comes to that defense. And so that issue is separable from the facts of this case.
Let me challenge that. I'm trying to follow your argument. For example, if I was a defense attorney and I indicated that I was going to introduce an alibi witness and provided you that information as mandatory discovery, yet during the course of the Commonwealth's case in chief, I found that I would not be able to introduce it because your case was strong enough to refute that. And I choose not to introduce alibi. Therefore, an alibi instruction is not relevant to the proceeding or an appeal, not even a collateral order. So following that hypothetical, share with me how you are any different. They hypothetically said we may introduce the peace officer's justification defense. They don't know what the Commonwealth is going to introduce or how the witnesses are going to testify or whether they're credible. So I'm really confused as to why procedurally you think you have a right to come to this court and ask us to strike something when it's not even before us.
Your Honor, the distinction between that hypothetical is that here the trial court made a constitutional ruling prior to trial on what the scope of that defense would be if defendant decides to raise it. In your hypothetical, there was no ruling of law on the bounds of the alibi witness law, which are separable and distinct as a matter of law, as opposed to, Your Honor, as defense counsel's intent to raise that at trial. So regardless of whether the facts here ultimately support the assertion of this defense, it's important that the trial court's constitutional decision pre-trial be corrected so that if this issue comes up, the jury is properly instructed.
Counsel, in other words, if the trial judge had held it in abeyance, held the issue in abeyance until later in the trial to see if the defense really materialized, you wouldn't be here, but your position is because there was a pretrial ruling, you can be here, and then we get into the collateral order issue.
Well, if the trial court had held it in abeyance, then we couldn't be here.
Correct.
Your Honor, because of double jeopardy protection.
That's what I just said.
Exactly. So that brings us to a very important element of both the collateral order doctrine and Rule 311D, which is that the issue would evade review if not appealed prior to trial.
Counsel, I read that in your brief.
Every district attorney in the United States lives with that as to every decision made during the trial. Be it a suppression motion, be it an evidentiary ruling, being it a ruling on the charging. I mean, it's cliche that you can't appeal because of the double jeopardy clause, and therefore rulings that are adverse to you go by the wayside if there's an acquittal. We can hear this case on this issue in due course if you get a conviction and the other side takes an appeal arguing this defense, if the defense is even raised and considered or given. It seems to me that the trial court, two things. I think the trial court did hold this in abeyance. All the trial court said was, well, it didn't hold in abeyance your argument that you want him to rewrite the statute. He said that he doesn't have the power to do that. You have to go see the legislature. His role is to say constitutional or unconstitutional. That's our role also. We're not in the business of writing legislation. It would be a violation of separation of powers. And he can decide, he said he'll decide in due course whether or not to give the charge, and he'll shape the charge in a charging conference. So I'm not sure what your objection is.
Well, that's not my reading of the trial court's ruling, Your Honor. And again, this brings us back to the distinction between the legal question in this case and the factual question in this case. And what the trial court did, I think, is hold in abeyance the factual question of whether this defense will even be able to be raised at trial. And that's fine. The Commonwealth takes no argument with that. But the court did deny the Commonwealth's constitutional and legal argument, which is that this justification and jury instructions have to be interpreted constitutionally. The court's...
Let me stop you.
Okay.
Justice Doherty?
I just want to, let's follow that argument. So pursuant to 311D, you have to certify pursuant to 904 of the Appellate rules that this is going to, terminate or create substantial hardship with the presentation of your case.
Yes.
How does a justification jury instruction defense prevent or create a hardship or terminate your prosecution of this case? If you have evidence so overwhelming that it's murder in whatever degree you so choose to bring, your evidence should present that. So, for example, the way I've always viewed it as an assistant district attorney as well as a defense attorney is I terminate your case if I suppress as a judge your evidence. You can't go on. But share with me, how are you defining termination and or substantial hardship for 903 for your 311D, 904?
Well, Your Honor, I'm defining it as this court has defined it in its precedent, and I think those cases do not support the conclusion that the order has to actually terminate the case in terms of it not being able to go forward if the evidence is dismissed, for example.
Well, it's disjunctive. That's what Justice Doherty was just asking. It's either terminate or create a substantial hardship.
Exactly, but in response to that hypothetical of if evidence is suppressed, the case is effectively over, I don't think that's required in all cases under Rule 311D. And
what's the end point of your argument? I mean, if this is fodder for 311D, what pretrial ruling against the Commonwealth would ever not be 311D?
Well, I think that this is a very unique case where the Commonwealth is arguing that there is an unconstitutional defense that will be raised at trial, the elements of which are prohibitive to potentially to a finding of guilt despite being adverse to the United States Constitution. So I don't think that this would be warranted in every case where the Commonwealth disagrees with something that's going to be raised at trial. And certainly I think this court could craft a ruling that limits it in that way. And Rule 311D already makes it incumbent on prosecutors to use their discretion when seeking this remedy. There's actually not even any qualifiers in Rule 311D of when the Commonwealth can exercise this rule. Now, this court has created some exceptions to that in Kosnek and Shearer, but the rule is still very broad. And if a prosecutor was so inclined to unethically bring appeals that were not substantiated on the rule, they could already do that. So I don't think that this is going to open the floodgates in that way, particularly if this court limits it based on the procedural posture of this case.
May I ask you before you conclude, what remedy do you want? Do you want us to find that this is unconstitutional, or do you, as the trial judge thought you did, want us to rewrite it?
I do not want this court to rewrite the statute. I think there are multiple ways that this court can interpret the statute such that it meets constitutional requirements. And I don't even think that this court necessarily has to find that it is expressly unconstitutional to do that. Now, the Commonwealth's argument is that the statute is expressly unconstitutional under Garner and Graham versus Connor because it does not limit deadly force to where objectively necessary to prevent death or serious bodily injury. And so the argument is that the forcible felony justification and the deadly weapon justification do not meet that standard because they allow an officer to claim that he was justified in using deadly force even where it's not necessary to protect.
So are you asking us, just to follow up on the Chief's question, are you asking us to creatively reinterpret the statute, or are you asking us to strike it as unconstitutional?
Well, I think this court could do either. And I think that there's multiple ways to do this. So if the court, the bottom line here is that this is an ambiguous statute. And the reason it's ambiguous is because defendant and his amicus and the Pennsylvania State Police in arguing to Congress and multiple federal district courts have already held that the statute requires, or not held, I'm sorry, have already asserted that the statute requires what the Commonwealth is saying it requires in this case. But when you interpret the statute strictly disjunctively, as the trial court said that it would do, that's not true. The statute does not require the constitutional standard for deadly force, even though defendant is claiming that it does. And so where you have this ambiguity, I think that this court is entitled not to rewrite the statute, but to address that ambiguity.
Didn't you just make Justice Dougherty's argument that we need a factual record? Assume hypothetically that this officer takes the witness stand and testifies he was afraid for his life when he used force. He no longer has a police officer justification defense that is, even in your mind, consistent with United States Supreme Court law, because we struck the statute in an abstract, no facts to analyze kind of scenario. We can't do that to him.
He would still have a defense, Your Honor. And to be clear,
The statute's gone.
I apologize.
There's a Supreme Court decision that says the statute's unconstitutional.
Are you looking for prospective relief?
That would be part of what we're asking this court, certainly, but we also would like this to apply to this defendant as well.
How?
That's the question, because suppose you prevail on your constitutional argument. There is no scenario, so long as we have the ex post facto clause, where this could apply to Mr. Pownall, is there? Otherwise, you're violating ex post facto.
Well, I think the analysis here is under the due process requirement for a fair warning. And what
We've got that too, but you've still got that pesky ex post facto clause.
My reading of this court's decision in Commonwealth versus Rose was that it was applying Rogers versus Tennessee and saying that the ex post facto clause itself does not apply to judicial interpretation of legislative acts. That falls under the due process clause, which requires fair warning. And the Commonwealth's argument is that fair warning was met here, being that this constitutional standard has been in effect since 1985. Defendant is now coming to this court and arguing that the statute already requires what the Commonwealth is requesting this court make explicit, and that his police department policies codify that same thing. So
Respectfully, defendant's not coming to this court at all. Defendant's being hauled into this court by you. But
understood, Your Honor.
Go ahead.
But the fact of the matter is that defendant in his brief states that Section 508, quote, permits the use of the justification defense only where a resisting or escaping individual poses a threat of serious physical harm to the officer or to others based on the totality of the circumstances. That is what defendant is claiming is required by this statute, even though the trial court ruled that it would not impose that interpretation in the form of jury instructions. And so it does not make sense for defendant to claim that, but then also claim that he could not have foreseen this interpretation applying. And just to backtrack to what we're asking this court to do, we are not asking that this court strike the statute entirely or deprive defendant of a justification defense. In fact, it is the Commonwealth's position that police officers are entitled to a defense that is more lenient or goes beyond what ordinary citizens can use in self-defense. But the thing is that is already allowed for by the first part of Section 508, which allows police officers to use deadly force anytime it is objectively reasonable to prevent death or serious bodily injury. So that core paragraph 1 of the statute already provides defendant with an increased right to use deadly force. It's subparagraphs I and II which raise the constitutional issue. So I do think that this court could elect to strike those two subparagraphs And going back to what you said, Justice Barrett, that does not require a consideration of the facts at trial. It just means that once the jury hears the facts that happened, be it that the officer feared for his life or reasonably believed that deadly force was necessary, he is still going to have that justification defense that's codified in Section 508, paragraph 1. However, when it comes to those subparagraphs, they are ambiguous and they are not being properly construed by defendant and the lower court.
Counsel, if I may follow up on that argument.
Absolutely.
On page 21 and 22 of your brief, you're discussing your foundational point, that being, as you write on first paragraph or finishing the beginning of the paragraph 22, furthermore, in contravention of the Fourth Amendment, the statute's mechanical list of circumstances warranting death forgoes any independent requirement that the officer possess an objectively reasonable belief that such extreme action is required to prevent death or serious bodily injury. When you're looking at 508 in its totality and you see the conjunctive and disjunctive and or used in the same subpart, share with me how you rationalize or what you're trying to tell us with that comment on page 22, because I don't see it.
Absolutely. So in paragraph 1 of Section 508, it does say that an officer is justified in using deadly force only when he believes that such force is necessary to prevent death or serious bodily injury to himself or such other person. That is the constitutional standard. Then there's a comma and or when he believes that. And then there's the subparagraphs, which allow an officer to use deadly force where it's necessary to prevent the arrest from being defeated by resistance or escape, and he has committed a forcible felony or possesses a deadly weapon, or there is some other indication that he's endangering life. So those two middle parts that are embodied solely in the subparagraphs, they are separated from the constitutional standard in paragraph 1 by an or, and they are separated from the constitutional standard at the end of subparagraph 2 by an or. And what that means is that it is allowing an officer to justify deadly force only where there is a fleeing forcible felon and someone fleeing in possession of a deadly weapon. There's no independent requirement for those justifications that the force be objectively reasonable, as the Fourth Amendment requires. And so that's the problem with this statute. And so what I think can be done to solve that either is, as the Commonwealth argued below, to interpret the ors in subparagraph 2 conjunctively, such that the deadly weapon and forcible felony justification would also require that third part of subsection 2, where the suspect is endangering human life. Additionally, I think this court could strike subparagraphs 1 and 2, because again, there's already a constitutional defense in paragraph 1 of the statute. Another solution...
Counsel, can I stop you there?
Yes, please.
Explain to me how you would like to see subparagraph II to read. Are you suggesting, what is it in your view supposed to say? And otherwise indicates that he will endanger? What or are you changing to an and?
It could be, so yes, an and right before that otherwise, I think would render this constitutional, or at least more in line with constitutional requirements, because
well, I understand your argument, but if you're correct that this is that there's a constitutional problem, it would seem the only way to correct that is by striking subsections I and II, because as I read this, the legislature is making an indication of what it perceives to be evidence that the defendant here will endanger human life or inflict serious bodily injury. As I read this, they're saying II the portion that says the person to be arrested has committed or attempted a forcible felony or is attempting to escape and possesses a deadly weapon, to me, that's the legislature saying those factors indicate that he will endanger human life and inflict serious bodily injury. So, can the legislature make an evidentiary determination like that, that those factors indicate that the potential arrestee is dangerous?
No, I think that this court has to make that explicit. To the extent that that's what the legislature thought.
That's why I don't know how changing that "or" to "and" fixes subparagraph II.
If all of the "ors" in II were changed to "ands," then it would require, it would allow for deadly force where there is a forcible felon who's fleeing with a deadly weapon and indicates a danger to life and safety.
Well, how do we have the authority to just magically change a word the legislature wrote in the statute?
Well, under the rules of statutory construction, "or" can be construed as conjunctive, where to do the opposite would render the statute invalid, in this case constitutionally invalid.
Assuming that's correct, you're not asking us only to interpret that last "or" to be an "and," you're also telling us to strike "otherwise." That's my point about the evidentiary presumption that the legislature is making in that first clause. That's one way to establish that he'll endanger human life. And then it says, "or otherwise indicates that he will endanger human life." So just changing "or" to "and" doesn't fix it. We'd also have to strike "otherwise." So to me, your stronger argument is, in order to fix this, presuming it's unconstitutional as written, I and II need to be stricken.
I think that would be a good solution, given that paragraph 1 already contains a suitable and constitutional justification defense.
Can you explain, give me your argument as to paragraph 1, where it says, comma, or when he believes both that, semicolon, colon.
I'm sorry, what?
How do we, when you say that it's directed to the public that paragraph 1 is constitutional, how do you argue that when the last sentence makes no sense? Or when he believes both that? If we follow the recommendation of Justice Donahue, strike 1 and 2. What you're really asking us is to strike the entire statute.
Well, yes, if you struck 1 and I and II, then that last part of paragraph 1 that pertains only to I and II would also need to be stricken as well. But because everything that follows that comma, where it says "or when he believes both that only pertains to the following two subparagraphs. So that would also have to go if those.
Counsel, what's the standard that we would need to follow engaging in severability analysis there?
In the separability analysis?
So in your option 1, your option 1 is to strike subchapter or subsections I and II and to strike that final clause of the preceding paragraph.
Yes.
What is the standard for severability analysis in determining whether that's appropriate?
Well, I think that it is give me 1 second. So I think the standard comes from what the General Assembly has enacted as how to interpret their legislation, which is that they don't intend a result that's impossible of execution or to violate the Constitution of the United States or this Commonwealth. And so where that happens, this court is permitted, where there are multiple reasonable constructions of a statute, to choose the one that avoids a constitutional issue. And so that's the standard that applies here. If paragraph I and II are given the effect that the trial court would give them, then they allow a police officer to claim in court that he was justified in performing unconstitutional deadly force. That would raise a constitutional problem. And so what we are asking is for this court, in light of the ambiguity of this statute and how difficult it is apparently to understand how to put it into effect, we are asking this court to make a ruling that it must be put into effect in a constitutional way, that it cannot be applied in a criminal trial in a way that permits defendant to raise a discrete justification under those two unconstitutional sections of paragraph II.
I think we understand your argument. Thank you very much.
Thank you, Your Honors.
Good morning, Mr. Chief Justice and Associate Justices. My name is Charles Gibbs. I'm joined by my colleague, Brian McMonagle, and we represent Ryan Pownall. I am. The question before the court is simple, we believe. Did the trial court appropriately decline the Commonwealth's invitation to usurp the legislature by refusing to write Section 508 of the Crimes Code to help the Commonwealth meet its burden of proof? The trial court appropriately ruled that without evidence, without hearing any evidence, it would be impossible to decide what jury instruction it would give. The trial court indicated that at the appropriate time, it would make the appropriate ruling. The Commonwealth, in essence, forced the trial court's hand and insisted that the trial court issue an opinion. The court was left with no option. She had to determine that the motion to eliminate would be denied because there was no evidence for her to rely on. The Superior Court appropriately quashed the appeal.
Just a second, I want to make sure I understand. How did the trial court have to do that? I mean, can't a trial judge say, well, I'm going to hold the motion in limine in abeyance, I'm going to hold this issue in abeyance and see how it plays out at trial as to whether a ruling is required?
Trial court indicated on the record that she wanted to hold it in abeyance. The Commonwealth insisted that there would need to be some appellate review, and as a result, the trial court issued an opinion to haste so that Mr. Pownall's trial wouldn't be delayed unnecessarily.
So she was persuaded to do it. She didn't have to do it.
She was persuaded to do it. That's appropriate.
Okay.
I think it's appropriate to look at the background on this case. On June 8th, Officer Pownall encountered an armed felon and wrestled with that felon for a firearm. On September 4th, 2018, the District Attorney's Office charged Officer Pownall. On November 25th, 2019, on the eve of trial, the Commonwealth files its motion to eliminate. The trial court noted in its opinion that the Commonwealth did not argue that the statute was unconstitutional. Instead, what the Commonwealth asked the trial court to do was to change ors to ands. The trial court appropriately noted that she did not have the authority to be the editor of the General Assembly. In fact, this court has ruled 20 years ago that it's not your role to be the editor of the General Assembly, but instead to interpret the statutes. The trial court noted that she could not usurp the legislature, and as a result, the District Attorney's Office filed an appeal to the Superior Court that was quashed because the Superior Court appropriately noted that they had no jurisdiction. Respectfully, this court does not have jurisdiction when you look at the rules of appellate procedure.
Well, how can that be if something's unconstitutional? That's our role going back to Marbury, isn't it?
It is. However, that was not the issue before the trial court, whether the statute was unconstitutional. When you look at the motion, they're not asking to declare the statute unconstitutional. In fact, during our argument today, I don't think the court got a straight answer of what we're asking for.
Are you saying that the constitutional question is not properly before us?
Not at this time.
Didn't that Superior Court footnote put that before us?
It did. However, there's no factual basis for us to have that determination at this time.
Following up on that assertion that we don't have a factual basis, isn't the expression of an intent to use the peace officer justification defense sufficient to bring the matter into play for collateral order purposes, because each side needs to plan its case?
The collateral order elements require that it be separable, and you cannot separate whether or not Mr. Pownall is allowed to raise an affirmative defense without ruling or making some determination on his guilt. It's not separable. So as a result, all the elements aren't met. The Commonwealth asserts the second element requires that it be of grave public importance. The Commonwealth had a number of remedies to get to this court. They could have filed a King's Bench petition to get to this court to have determination made on whether or not this statute's constitutional or not. The Commonwealth did not do that. They waited to the eve of trial. It's also our position that Section 508 wasn't.
Yeah.
It is very difficult. It is very difficult. They could do that, or they could have filed a writ of mandamus, a petition for a mandamus determination. It's.
And if that's so, if they could bring the merits of the issue before us, using a declaratory judgment or a mandamus, then why shouldn't we just cut through that procedural quagmire and nicety beside us?
If the court decides to do that, that's appropriate. Our position is the statute is constitutional as written. My initial position is that the court does not have jurisdiction at this time pursuant to the rules of appellate procedure. We don't get to bypass the rules in order to help the Commonwealth meet its burden of proof.
Counsel.
At 508.1I, is it something that may be unconstitutional under Tennessee versus Garner? I don't know if it is or isn't, but they'll never be able to be review of it because as soon as the trial court gives that and there's an acquittal, then the Commonwealth can't appeal. As soon as the Commonwealth gives that or refuses to give that charge and there's a conviction, you're not going to be complaining about that.
We would not be complaining, but that is the system. No, it does not. The Commonwealth still has the ability to have review through some other action that doesn't necessarily hinder or is on the back of a United States citizen who stands accused of murder in a courtroom.
But counsel, isn't the whole purpose of a recognition of interlocutory appeals the fact that the appeal can be taken at a time that's opportune within the context of the proceeding? So, I mean, if you agree that this very well might escape review, isn't this exactly why we have the collateral order doctrine?
Or is it that the collateral doctrine order would be invoked at the end of the defense case in chief prior to the introduction of the jury instructions? The collateral order would go up with the record for the justification as to whether it's constitutional or not. That's how I think most jury trials would proceed. This is an anomaly that the first time I've ever seen Commonwealth introduce a jury charge without the introduction of some defense evidence. Pre-trial.
So I'll start with you, Justice Donahue, and then move to Justice Dougherty. Justice Donahue, the interlocutory appeal by right is for those times when a court's ruling has handicapped the Commonwealth. Frankly, if the judge.
No, that's the standard for the other interlocutory appeal that we're dealing with here, which is sort of in the discretion of the Commonwealth to say it impacts our case. I'm talking about the standard collateral order doctrine.
Collateral order doctrine, okay. In order to review the collateral order doctrine, there must be the ability to separate the ultimate issue from. The trial court would have to make a determination about the ultimate issue in order for this to come up. The ultimate issue here is the defendant's guilt or innocence. It cannot be separated from the Commonwealth's motion because.
That's what I don't quite understand. I mean, sure it can. I mean, the question of whether or not the manner in which the trial is going to proceed is constitutional is certainly separable from the issue of the defendant's guilt or innocence.
Justice, it requires an analysis of the evidence, and at this time there is no evidence, which actually
Why
goes.
is that true? You keep saying that the prosecution said it. Explain to me why that is.
In order to determine whether or not Mr. Pownall is entitled to raise this justification defense, some type of evidence would have to be presented. It's an affirmative defense. Either someone would have to testify namely Officer Pownall or another officer, about what was going through his mind. What was the evidence at that time? What were the circumstances in order to make the determination on whether or not this jury charge is allowed at all? To say that we are going to review a jury charge without any evidence is putting, frankly, the cart before the horse. And I don't.
It's sort of interesting because it could be that this is just a fault in the manner in which this entire case and appeal was developed, because it's clear to me that what we're talking about is the constitutionality of the statute that underlines the jury charge.
And the trial court wasn't.
And interjecting the fact that this happens to be encompassed within the jury charge doesn't really make a whole lot of difference to me in the analysis.
The trial court, I think, would be appropriate to review if the trial court made a determination of the constitutionality. The trial court made a determination that she couldn't rewrite the statute as the Commonwealth wanted it rewritten, which is a constitutional issue also under the separation of powers doctrine.
Well, I have a question. Oh, go ahead, Justice.
Just one final question. Are you saying that the Commonwealth never challenged the constitutionality of either the jury charge or the predicate statute in the trial court?
The exact language they used was, they never said the statute was plainly unconstitutional, but that it could give rise to an interpretation that was unconstitutional.
Oh, okay. Well, okay. Thank you. You answered my question.
Before we move on, Justice Doherty, did you get your answer? Yeah. Okay, Justice Pownall.
Actually, you've answered my question. Thank you.
Thank you.
Counsel, just to follow up, the issue about a particular suggested standard jury instruction is really academic or irrelevant. The issue is the statute.
Absolutely.
And I don't understand your argument against the applicability of the collateral order doctrine. This seems quintessentially like a collateral order. I guess perhaps I'm not understanding what you would say is the main cause of action. Is it the question of the defendant's guilt?
Guilt or innocence, yes, that's the main cause of action. And in order to consider what a jury charge is at that time, the court would have to make some determination. I understand the court is asking a question about the constitutionality of the statute. Frankly, it's our position that the statute is constitutional if you want to review it.
Right, and putting the charge aside, because I understand that's, channeled that way, it plays into the question that's arisen about the, need for a factual predicate or whatever. But looking at the statute question, isn't it quintessentially a collateral order type of matter, given that the Commonwealth and the defendant are both entitled to know whether this statute is constitutional or not? I mean, we still have the ex post facto problem I raised earlier, but it seems to me that this quintessentially is an issue for the court, is because you're both entitled to know what the law of the land is, so to speak, what's constitutional before you have to try your case.
If that's the case, and any time the Commonwealth disagrees or just asserts that something's unconstitutional, we could be in front of the Supreme Court. And that is not how the rules have been established thus far. It requires that the question be separable. We concede that this is a matter of grave public importance, but we also don't see how it's separable from the main issue, whether this statute is unconstitutional, because the ultimate issue is that on the date of this unfortunate incident that gives rise to this case, the statute was not deemed unconstitutional. So we can't retroactively apply
that's there. That's there, but prospectively, you see, this seems to be, this may be the first time, as Justice Doherty suggested, that the Commonwealth's brought this.
Yes.
But now it has brought this. And I take your point about ex post facto, but prospectively, I'm not so sure you're right.
Prospectively, I may be wrong, but I'm here representing Officer Pownall. And Officer Pownall, we can't have a retroactive application of the law on him on that day.
Mr. Gibbs, I think what the Commonwealth would say if they had response is that this is not an as-applied challenge to this statute. This is a facial challenge, that we don't have to look at all of the facts as to whether force was necessary, or was it defeated, or was there resistance to escape, or whether the person committed or attempted to commit a forcible felony. We don't need any of that. What they're saying, and I don't know if they're right or wrong at this juncture, is that under no set of circumstances whatsoever can I or double I stand under Tennessee versus Garner.
I disagree with the Commonwealth's assertion. Tennessee versus Gardner, as this court well knows, was a civil case. It did not necessarily address whether or not an officer was reasonable in using force in a criminal context. A review of 501 of the Crimes Code also notes that when we see the word believe or believes, it's a reasonable belief. Tennessee Gardner stands for the proposition that the officer cannot use force unreasonably. Our statute also takes into account the officer has to have a reasonable belief. The Commonwealth has chosen to ignore 501.
So if I can interrupt you, what you're really saying, and you've done it very adroitly, is we need a record here before we can consider this issue.
Yes, Your Honor.
All right. Anything?
Counsel, just one follow-up question. Putting the retroactivity issue aside, wouldn't the defendant want to know prior to going into trial whether or not the statute upon which he was relying was unconstitutional?
It's very hard to put the retroactivity.
Oh, just put it aside for a minute. I mean, that's what makes this a collateral order case, an interlocutory appeal case, because of the fact that this piece of law is critical to the adjudication of the case, whether you're the defendant or the prosecution.
The defendant would want to know that. I will concede that. However, on the date of the incident, he had no reason to believe that the statute was unconstitutional.
I understand that, and I could understand also why you would want this charge as written to go forward in this case. I understand that entirely. But because of that, the likelihood that this issue is going to evade review becomes more probable than not. I mean, and I think, you know, that's why we're here and why we've taken this whole issue of the appealability of this issue so seriously. If this is going to evade review, now's the time to decide it, whether or not you're in agreement with the Commonwealth's position or not.
Yes, Your Honor. I think that while it may evade review, the appropriate remedy is to go to the legislature and have the legislature draft a statute that they, to change the statute.
True, but we would first have to say it's unconstitutional to get the legislature on the mark. Get ready, set, go.
That's correct.
Do something else.
But
so,
there's actually a bill in Harrisburg that was attached to the Commonwealth's brief that talks about this very issue. So the legislature can consider this at any time. It doesn't have to be because
Mr.
of
Gibbs,
Mr. Pownall's case.
I'm thinking out loud, but don't we get, I'm trying to think this through, it's an interesting question. Don't we in fact get to this if after full development of the record, the trial court looks at all the law and says, I'm not charging on I and double I because I think that it's not consistent with U.S. Supreme Court law or whatever. Then your client is convicted. Then you take an appeal and say, we were entitled to charge under I and double I, and then we have the issue as framed by the trial court with all the facts replete there.
Absolutely.
And that's not an unlikely scenario if you don't get to use I and double I. Depending, again, we have no idea, but it's not unlikely that you get convicted and you're back here saying you should have used it.
And then the court would have the opportunity to review, which means it didn't evade review.
I think I figured it out. Thank you. Anybody? Anything you want to say in closing?
No, thank you.
Thank you very much.
Mr. Davis, is that a Pittsburgh Pirates mask you're wearing? Is that a direct appeal to the 4 Western Pennsylvania justices?
Your Honor, I actually objected to the mask.
All
The
right.
objection would be more meaningful if the Pirates played Major League Baseball. This case involves Act 129 of 2008, addressing the use of smart meter technology by large electric distribution companies. The Public Utility Commission interpreted Act 129 as mandating universal deployment of smart meters for all consumers of large electric distribution companies. Several consumers currently before us have objected to the installation of the smart meters, claiming they emit radio frequency electromagnetic energy, which results in either unsafe or unreasonable service. The Public Utility Commission dismissed their complaints, concluding that Section 2807 of the Public Utility Code mandated installation of smart meters without the ability of a consumer to opt out. On appeal, the Commonwealth Court held that Section 2807 did not mandate universal installation and remanded to the Public Utility Commission to reconsider consumer complaints. The PUC and PECO Energy Company and consumers all sought reviews of various aspects of the Commonwealth Court's decision, and this court granted those appeals in part. So specifically, we're going to consider whether 2807 mandates universal deployment of smart meters, and if so, what is the consumer's burden? If not, I suppose, what is the consumer's burden in proving that an energy company failed to provide safe and or unreasonable service? Now, obviously, we have a great many lawyers. I am going to be vigilant to enforce our no repeat rule, because we don't want to be here hearing this argument at dinner time tonight. So appreciate everybody trying to stay in your lane and give everybody a chance to say what they'd like to say. All right, I think, is Ms. Tran, you're going to argue first for the PUC? Please go right ahead. And as before, in this complex case, if I've said something that you disagree with, feel free to explain it to me.
I think Your Honor has accurately summarized. Good morning, Mr. Chief Justice and honorable justices of the Supreme Court. May it please the court, my name is Tiffany Tran and I represent the Pennsylvania Public Utility Commission. Today I will explain to the court how the Commission and PECO got this case right and the Commonwealth Court got it wrong. The Commission's positions regarding the Commonwealth Court's ruling in Povacz has been extensively presented in the Commission's 2 briefs filed with this honorable court. However, in my argument today, I will be focusing on 3 main issues. First, how the Commonwealth Court erroneously interpreted Act 129 by reading an opt-out into the General Assembly's mandate for universal smart meter deployment. Second, how the Commonwealth Court's interpretation of Act 129 creates absurd results that frustrate the General Assembly's intent. And third, how the Commonwealth Court mishandled Section 1501 of the Public Utility Code in its decision. Mr. Kulak, who represents PECO, will, consistent with this court's grant of aliquotter in PECO's appeal, be addressing the Commonwealth Court's erroneous interpretation of the term furnish as it appears in Section 2807 F2 and the impact of this interpretation on utilities. PECO will also be addressing the consumer's contentions regarding their burden of proof and the flaws in a standard for utility service based on their individual peace of mind. The Commonwealth Court held that nothing in the language of Act 129 requires electric distribution companies, EDCs, customers to accept smart meters. This is incorrect. As explained in the Commission's initial brief at pages 16 through 23, Act 129 clearly mandates universal deployment of smart meters within a 15-year period. This was supported by the partially dissenting, partially concurring opinion filed by Judges Crompton and Visano-Cannon in the Commonwealth Court decision. Section 2807 F2 states that electric distribution companies shall furnish smart meter technology. What follows is a list of 3 provisions under which smart meters must be deployed. When read together, these provisions lay out the General Assembly's plan to ensure universal smart meter deployment. Section 2807 F2 III sets forth a 15-year time frame for impacted EDCs to construct the metering infrastructure required to support smart meter functionality and replace all legacy meters within their service territories. Yes, Your Honor.
Maybe you could spend a little bit more time and educate me on what precisely III means. Depreciation is an accounting term of art, and explain to me how that translates into the position that this is a requirement for furnishing the smart meter technology.
Yes, Your Honor. And this goes to the Common Coalition's interpretation of the matter, when you read all three provisions of Section 1I, 2I, and III of Section 2807 F2 together, they set forth what is a timeline for smart meter deployment. If you look at the legislative history of Section 2807 F2 III, the previous iteration of the language says that the depreciation schedule is for the existing meters, full depreciation of all existing meters in a term of 15 years. So,
Existing meters,
existing
meaning
meters-
not smart
not
meters?
smart meters, Your Honor,
Okay.
the meters that are currently existing at the consumer's residences. If this list of provisions was read in any other way than a 15-year mandate, Section 2807 F2 would not make any sense. Some of the results that would occur would be that you have a provision in 2807 F2 2I that mandates universal deployment of smart meters for all new construction upon the passage of Act 129, 2008. If Section 2807 F2 III was read as an accounting mechanism, this would effectively result in a situation where the entire burden of the General Assembly's mandate of reducing electric consumption would be placed on new construction that didn't even exist yet. It would be exempting all previous construction that existed at the time of the Act's passage in 2000.
Okay, I mean, I may agree with your ultimate conclusion on this, but maybe for different reasons, because when they're referring to depreciation, a depreciation schedule here,
Yes, Your Honor.
is it your position that they're referring to depreciating the newly installed meters, or is it the depreciation of the existing meter technology?
Your Honor, it is the Commission's position that we are talking about the depreciation of the legacy meters, and this was explained in the Commission's implementation
I
order.
understand that, except those depreciation schedules by accounting principles were previously set, were they not?
Your Honor, those would have been determined by the Commission. There is a provision 2807 F27 that discusses the fact that the Commission will determine the depreciation schedule for the meters. And if I may continue my argument, Your Honor.
Let me just ask you one more question. Sorry, I sort of understand the context of all of this. Small I gives a preference to consumers who, on request, ask for the meters and agree to pay for them at the time of the request.
Yes, Your Honor.
Okay. Let's take every other consumer, and they're just part of the mix of who are ultimately going to get a meter. Who pays for those meters?
The meters in 2807 F2 1I are paid for by the consumer.
I understand that. What about the other
In the
consumers?
others, they are recoverable through rates assessed on all ratepayers.
Okay, so ultimately, the consumers are paying for the meters. It's just as part of their, what they pay for their electricity.
That is correct, Your
Okay.
Honor.
Yeah, Counsel, since because you've been interrupted, let me just ask you also. My current lean is that the Commonwealth Court got this exactly right. The legislature doesn't speak in code. The legislature says what it means, and it seems to me that you're grasping a depreciation schedule as a clear legislative mandate, which is a big deal. The 2 says, 2807-2 says, electric companies shall furnish smart meter technology. What I thought immediately is the federal government or government shall furnish COVID-19 vaccines. But we all know everybody doesn't have to go get them. And I just don't see how, so I appreciate you can't read from shall furnish that people have to accept it. So you fall down to a depreciation schedule and you ask us to glean legislative intent. Is that fair?
No, Your Honor, I would like to continue my argument in the interpretation. If you look
ahead.
at Section 2807 F5, respectively, Your Honor, it does cite to Section 2807 F2 III. And Section 2807 F5 talks about time of use rates and real-time price plans, and states that EDCs shall offer time of use rates and real-time price plans to all customers that have been provided with smart meter technology under Section 2807 F2 III. Residential or commercial customers may elect to participate in time of use rates or real-time pricing. Now, Your Honors, if it was the General Assembly's intent to read 2807 F2 III as merely an accounting mechanism, it wouldn't make sense for the General Assembly to have written in 2807 F5 a distinction between the offering of time of use rates and real-time price plans to customers and the provision of smart meter technology under 2807 F2 III. If you read 2807 F2 and 2807 F5 together, it clearly sets forth a 15-year schedule for deployment, universal deployment of smart meters to all EDC customers, and that for all the EDC customers who have been provided with a smart meter, they may have the option of taking advantage of time of use rates and real-time pricing plans.
You've lost me. I'm sorry. I
Yes, Your
don't mean to interrupt your argument, but even given what you've just said, individual customers still would have the right to refuse to have a smart meter installed at their home, wouldn't they?
No, Your Honor. The distinguishing feature here is that in 2807 F2, the justices have, remarked that shall furnish means that they do not need to accept. But in 2807 F5, the court doesn't use the permissive shall offer language. Shall offer relating to time of use rates and relating to real-time price plans, that is optional. If the smart meter deployment was likewise optional, in 2807 F2, the General Assembly would have likewise used the phrase shall offer. Instead, it used shall furnish, and again, if we go back to 2807 F5, the fact that 2807 F5 refers to all consumers that have been provided with smart meter technology under 2807 F2 3I, which is, again, the all-encompassing universal deployment within 15 years.
Counsel, if I may.
Yes, Your Honor.
I am in agreement with Judge Crompton's well-reasoned concurrence. Let's assume that what...
Dissent is...
yeah. He concurred with... I apologize. What we're saying, or is what I'm understanding you to say, is the statute indicates that smart meters will be mandatory and everybody will have them within 15 years. If you choose to want to have a smart meter immediately, you're going to have to pay out of pocket. And or new construction, it's mandated. Is that what you're sharing with us?
That is exactly the Commission's position, Your Honor, yes.
Okay. So let's assume that to be true.
Yes, Your Honor.
The more important part is the opting out. Do you believe the statute permits, pursuant to 1501, individuals opting out because of their fear or their concerns for RF?
There is no, Your Honor, there is no language. The Commission does not believe that there is an opt-out written into Section 2807.
So what makes you feel that the government should impose medical hazards on particular citizens?
Your Honor, in this case, the Commission reviewed the evidence provided by the consumers and reached a determination, which was upheld by the Commonwealth Court, that the consumers had failed to sustain their burden that there are any harmful effects from PECO smart meters. So you're phrasing that the government is imposing.
It's mandating.
It's mandating.
You're sharing with us,
Yes.
with all due respect, you're sharing with us that there's no opt-out, that we must get smart meters. And if we get smart meters, and I might have a concern about the radio frequencies and its harmful effect on me, what you're saying is too bad.
What I'm saying, Your Honor, is that in this case, the consumers were unable to prove that smart meters caused harm. And under the Commission's burden of proof, which is preponderance of evidence standard, which is evidence convincing by even the smallest amount, the consumers were unable to present any evidence, any competent evidence or credible evidence.
But let's take this to the logical extreme. We now understand by reading reports that in Havana, there's allegations that our American embassy was attacked with a different type of radio frequency that caused certain physical problems. When it happened, no one understood what it was, so how can they articulate what they don't know? So what you're sharing with us is that the government has a right to impose a health hazard on people and charge you for that health hazard without an opt-out clause. Do you really think that's rational? Is that a rational or is that an absurd comment?
Your Honor, it's the conclusion of the commission that this was based on the record before. The commission cannot read into the statute an opt-out that simply does not exist and cannot be read from the statute.
So you have to wait for someone's pacemaker to stop working, and then you'll have a claim that you can consider that there's a health hazard?
Your Honor, again, the commission cannot decide an interpretation of the statute based on things that have not been proven, have not been...
Although the standard is unsafe or unreasonable, why isn't it almost per se unreasonable for the commission to impose in this case, radio frequency emissions on unwary public when the state of medical science is such that it can't be proven that it's not, that it's safe or unsafe? You're saying they didn't meet their burden of proving unsafety. Maybe per se they met their burden of proving unreasonability.
Your Honor,
But go back to 1955 and you're standing here telling us, well, there's no proof that cigarettes cause cancer. Mm-hmm. But in fact, they do cause cancer. However, plaintiffs couldn't prove it in a court of law because or the PUC because of the rules we have. So why isn't it unreasonable?
because the standard for, reasonableness and safety under the Public Utility Code, which is Section 1501, effectively they have failed to satisfy their safety burden, as Your Honor has articulated. But the fact is that, and the Commonwealth Court said this, when considering accommodations on remand and whether the PECO acted unreasonably, they said to take into consideration safety concerns. It would be illogical for the Commission to say that you failed to sustain your burden on safety, but we're going to find that the utility acted unreasonably because you have safety concerns, which you have failed to prove. It's a circular thing that would apply to any number of utility actions. It could apply to pipelines, hazardous liquids and gas.
It absolutely could if the science was uncertain.
Right. It could apply to transmission lines. It could apply to chemicals treating water treatment plants. So you could be in a position where anybody could come before the Commission, file a complaint, fail to prove that the utility's actions are unsafe, but they say, well, but we're still concerned, so it's unreasonable as long as you still have safety concerns. It would be impossible for utilities to be able to determine if their conduct is reasonable, if they are constantly at a risk of having to be responsive to safety concerns that are not borne out by evidence presented to the Commission.
But Counsel, that wasn't the holding of the Commonwealth Court. I mean, they said when considering the unreasonableness, the safety concerns could be part of the totality of circumstances. So reading that as written, if the only evidence of unreasonableness is a safety concern, they're going to lose, because there are no other circumstances to consider within the totality. So what is wrong with that protocol or that procedure that was set up by the Commonwealth Court to determine unreasonableness, totality of the circumstances, including the potential safety risks?
Your Honor, because the Commission, and this is a position where the Commonwealth Court articulated that the Commission said it could not consider accommodations, and the record does bear out that the Commission did, in fact, look at PECO's tariff and determine that PECO's ability to provide a accommodation by moving the smart meter far away enough from the consumers' houses so that the RF emissions basically fell to zero. There would be no RF emission effect, was a reasonable accommodation. Now, the Commission cannot direct a utility to provide an accommodation that falls outside the General Assembly's Act 129 smart meter mandate. It's the accommodation that the Commission found currently and that it found to be reasonable is that moving the smart meter away, far away from the house, is where the effect of the radio frequency would have no impact on the home was a reasonable accommodation. Therefore, there is no need for remand to consider alternative accommodations, because the only accommodation that the consumers have asked for in this situation is an opt-out, no meter at all. Act 129 does not provide that. Act 129 mandates smart meters, and the accommodation that's provided addresses the consumer's concerns by removing the emissions of the smart meter exposure to the house by moving it far away.
May I ask you, is there such a thing as a wired smart meter?
Your Honor, can you please repeat that?
Is there such a thing as a wired smart meter?
Your Honor, what happened in the implementation of Act 129 is that the Act 129 sets forth certain baseline requirements for smart meters. And the record in this case, going back to when the PECO filed its smart meter plans and the commission was looking through, approving the EDC's various smart meter plans, there were no smart meters available that were wired that still satisfied the requirements Act 129 to have like bidirectional communications and other issues reflected in 2807 G and G3. So the question of is there such a thing as a wired smart meter? There is no wired meter that fulfills the functionality required by Act 129.
May I ask you, one last question?
Yes, Your Honor.
I'm sorry, Justice Mundy, you have a question?
I'll wait till you're finished.
All right. I'll ask one more question and yield the floor to Justice Mundy. I'm curious, the Commonwealth Court pointed out that all of the PUC's internet information spoke in terms of permissive language. This is an opportunity to get a smart meter. One-size-fit-all approach would not be the best approach. We should balance needs as consumers. And yet you're here today saying it's absolutely clear under this statute that this all has to be mandated. Did the Commonwealth Court misread your literature?
Yes, the Commonwealth Court did misread the literature. Initially, Your Honor, I'd like to bring to the Court's attention that none of this information that was on the Commission's website was brought before the Commonwealth Court by either the Commission, PECO, or even the parties. And it speaks to the ability for customers to choose to have time of use rates or real-time pricing. That's facilitated by a smart meter. It's independent from whether or not you get a smart meter. It's saying that you can choose what you want to do with the smart meter after it's been installed. So that is what I'm saying. It's not so much a question of do you get a smart meter or not. It's a question of in what the language that the Commonwealth Court cited to. It was, do you want to take advantage of the opportunities that are provided by the smart meter to reduce your consumption and manage your energy load?
All right, thank you. Justice Mundy, thank you.
I think that your answer to Chief Justice Baer's question resolved a little bit of my question, but I'm just curious, is the smart meter something that is installed for the benefit of the consumer, or is it installed for the benefit of the utility?
Your Honor, in passing Act 129, the General Assembly in the preamble to the Act stated that it was the intention of the General Assembly to provide a public benefit to Pennsylvanians by using this energy efficiency and conservation technology to reduce energy consumption and to benefit the environment. So the provision of smart meters is intended to facilitate programs that would be designed to reduce electric consumption and generally provide a benefit to the environment for less fuel consumption. And
does it provide the consumer with any type of cost benefit?
It can provide the consumer with a cost benefit through time of use rates and real-time pricing. Therefore, the consumer can track how much they're using and determine, I'm using a lot at this point. Maybe I can dial back what I'm using, or maybe I can go onto a plan that is more, takes advantage of the fact that certain rates are low at certain times of day. So that provides a benefit to them. Yes, Your Honor.
Your position is interesting. So when the benefit is to the PUC, the cost savings, which is not in the statute, not a determination of the PUC, that, your argument to us, we can consider. But an undefined medical diagnosis, because there's no such writing in the Act as you argued, should not be considered. How do you balance the two positions? What you just shared with all of us is that if it's advantaged to the PUC, it should go. And it's ultimately, you're saying, well, over the course of time, the savings will be upon the customer, but until then, you'll be paying us.
Your Honor,
Yet, medically, you're saying, well, they didn't prove that there's any tangible physical malady, therefore, the statute as written doesn't permit that. That's incongruous. Doesn't make sense.
Your Honor, may I ask you to clarify what you mean by
Yeah, what I mean-
benefiting to the PUC?
It's benefiting the PUC because you're charging,
It's the electric companies.
well, yeah, but the commission is allowing the customer to pay for a government mandate. And there's no benefit there until years down the road is what you're sharing with us, until we materialize that or it transacts over the course of 10 years. But yet, we're to understand and accept and rule that a potential medical dilemma has no opt-out or has no position in this mandate. I'm struggling with your argument.
Your Honor, it's still in Act 129, the interpretation is that there is no opt-out, and therefore all consumers have to get this smart meter. So the commission cannot read into it that there is an ability to opt out when, and frustrate the General Assembly's intent. The General Assembly clearly intended for these smart meters to be used for the purposes that are stated. And the General Assembly was the one who wrote that the utilities can recover the cost of these meters. It is not something that the commission came up with. The commission is only complying with what the General Assembly wrote in Act 129.
Ms. Tran, I have more of a practical question, I think, in terms of my understanding your argument than a legal question. You acknowledge that if special circumstances are presented, there can be special accommodations for an individual household to have the meter installed outside of the house, correct?
Your Honor, my explanation was it could be moved far away enough that the RF emissions from the meter would not affect the house.
So it's outside of the house?
Yes, Your Honor, and I believe all meters, smart meters, are located outside of the house.
So it's
rather
a
than
matter of
on
the
house.
distance
Yes,
from
Your
the
Honor.
house. So then why wouldn't the electric companies proactively just move all smart meters a sufficient distance from the house?
Your Honor, because the tariff approved by PECO, approved by the commission, PECO's tariff approved by the commission states that the movement of such meter would be at the cost of the consumer. So that
The consumer with the pacemaker?
the consumer with the concerns that the smart meters may affect them, yes.
Okay. Thank you.
So just to
Follow up there.
on the
Can I,
opt-out.
can I just follow up on that?
Yes,
Were
Your Honor.
the consumers in this case offered that option?
Yes, Your Honor, and they rejected that option.
Can I just follow up then on the accommodation language from section 1505A? You maintain under no circumstances, even the most marginal cases, the most well-substantiated medical cases, could never provide for an opt-out scenario. Is that what you're saying?
Your Honor, yes, Your Honor, that is what we're saying. And if we ever get to a position where a consumer does prove that a smart meter, the very small amount of RF emissions that a smart meter emits, is harmful, then we have a lot more problems than just PECO smart meters. RF is pervasive in society, and that would be something that would have to be addressed at a greater level.
Well, putting the societal concerns aside, why is it necessary to your argument that there never be any availability of any opt-out, even in the extreme cases? How would that displace the network effects?
Your Honor, if there was to be an opt-out, it would be, again, we go back to the decision, the commission's position that there is no opt-out. And when you say the most well-substantiated cases, I'm assuming can you please give me an example of what you're talking about?
In other words, supposing you're correct that it's well, I guess you're saying there's never an opt-out, but supposing that there's an opt-out, not an opt-in, why does it defeat the PUC's position to allow for the possibility that there could be marginal outlier cases where an opt-out is permissible, if substantiated.
This again goes back to the fact that there is no opt-out in Act 129, and the commission cannot direct a remedy that falls outside of the
Well,
General
just
Assembly's-
one follow-up on that.
Yes.
So, how do you support your interpretation of accommodation as allowing for something less than an opt-out in the extreme cases? In other words, what is the support for declaring that accommodation is simply defined by distance from the house?
Because what we have here, Your Honor, is the consumer saying, we're afraid of the harm that smart meter emissions can cause us. So by moving the meter away from the house to a level where the RF emissions do not reach the consumer's home, you have removed the concerns of the consumer at that point, because there is no impact of the smart meter emissions on the home, and
At the customer's expense.
at the customer's expense, Your Honor.
So, Ms. Tram, and I think I'm following up, and again, your position is absolutist from a very amorphous statute, but we'll put that to a side. We beat that dead horse. Assume that I'm a consumer. I come in. I bring my doctor. I qualify my doctor before wherever the fact finder is, be it a PUC referee or a trial court or the like. My doctor's an expert, and my doctor testifies with a reasonable degree of medical certainty that I'm impacted by radio frequency and that this is going to adversely impact my house. The trial court finds my doctor credible. My doctor finds the PECO doctor not credible. The trial court says accommodate him. You're saying that that's ultra vires because the statute says we don't have to accommodate him.
No, Your Honor, I'm saying that the accommodation that is provided under PECO's tariff to move the meter far away from the house is an accommodation that removes the radio frequency emissions from the consumers and still complies with the mandate back to 129 because a smart meter is still installed.
At the consumer's expense,
At the
right?
consumer's expense under the current tariff. Yes.
Well, never mind, I'll ask PECO. Thank you.
Counsel, just one question for my own clarification. It's your position that there are no opt-outs, absolute no opt-outs. But it's also your position that reasonable accommodations are available to the customer at their expense to the extent that the utilities tariff provides for such accommodation.
Yes, Your Honor.
Okay, thank you.
Ms. Tran, whether or not we ultimately agree with you, that will be decided later, but I would observe that you have a tremendous grasp of this issue and this information, and the PUC should be very pleased to have you representing them.
Thank you, Your Honor.
You're welcome.
Thank you.
We'll try to grasp it as well.
Mr. Kolak, I believe. And again, we've been far and wide with Ms. Tram, and to the extent you can add something that we've not already gone over, we'd appreciate that you try
Yes,
to
Your
do
Honor,
that.
if I may it please the
You
court.
take off your mask.
I would like to address a
If you
number.
don't mind removing your mask, it helps us understand you.
Thank you, Your Honor.
Thank you.
That will help. I actually would like to address a number of the questions from the company's perspective, having implemented this system and having addressed the customer complaints over the years. First of all, just going back to the beginning, where we were with the beginning of Act 129, we have a direction from the General Assembly to bring new technology throughout the Commonwealth in the form of smart meters to achieve environmental goals, reduce cost to customers of energy. How to do this was the question before the Commission. The Commission gave us implementation orders, and then each utility had to submit a plan to the Commission as to how it would do that. In PECO's case, very comprehensive plan with testimony by technical experts, and the result of that was a plan that was settled with the Office of Consumer Advocate, the Office of Small Business Advocate. A comprehensive settlement was reached that used wireless frequency, wireless meters to implement the statutorily required bidirectional capability that the smart meter system required in the view of the General Assembly. The effect of that, and that order was not appealed. Based upon that order, PECO invested $730 million into building the system.
But why does it defeat, I'm sorry to interrupt, but just why does it defeat that network effect, if I'm using the right term, that economy of scale or whatever the right expression would be? Why does it defeat that to allow for the accommodation language in 1505A to provide a safety valve that ALJs can partake of in sufficiently medically substantiated cases.
Your Honor, that is exactly what happened here. And to the Chief Justice's question with respect to the medical evidence, which I think you're also asking, that is what the proceedings were in these proceedings right before this court and before the commission. What happened there were experts testified on behalf of the complainants, and including experts testifying about the medical effects of this. All they could do was speculate that there could be harm. That is the factual record before you. On the other side, for PECO, you had both a medical expert and you had a scientific expert specializing in radio frequencies. The scientific expert discussed in detail the science here and showed how extremely low the transmissions of these meters are. It is less than a second. It is millions of times below the level set by the Federal Communication Commission. And the medical expert for PECO, with 40 years of experience, testified to a medical certainty that these radio frequencies could not cause the medical harm that the complainants were asserting. And their physicians who were coming in could testify they were suffering this, but they could not say that this was caused by this. And that is really the key question before you, which I do want to answer your other questions about depreciation.
I apologize. So is it PECO's position that while they're mandated, there is an opt-out basis pursuant to 1501 and 1505?
No. What there is, Your Honor, and what was offered here is a reasonable accommodation based upon the record here, which is, first of all, we're millions of times below the Federal Communication Guidelines, and I'll also talk about the D.C. Circuit decision as well, because I know that's of interest to the complainants. But we're millions of times below. Moving that meter 30 feet lowers it even further, another 100 times. So we are able to comply with the statute by providing a smart meter.
Let's hypothetically say, I grew up in South Philadelphia. You move a meter 30 feet, you're in somebody else's property.
Yes, Your Honor. I also live in a garage, Your Honor. I know that's a challenge.
How's that a reasonable accommodation?
It is for the complainants who are presented here, but the accommodation, again, Your Honor, we're talking about a meter that is already transmitting for less than a second millions of times below. If they are able to make out a case for a reasonable accommodation, we can offer it, but in fact, the commission went beyond it because in this case, they didn't even make that case out. The commission went the extra mile to consider their evidence, to offer that accommodation, but the evidence wasn't there. That's what was before the fact finder in this case.
But if we understand, if I think that PECO's position, based upon what the PUC had to say, is you'll accommodate any consumer that'll pay for it. Is that accurate?
And that, actually, Your Honor, those were tariff provisions in our tariff before Act 129. We are always able, and according to our tariff provisions, will assist customers who relocate meters. People have different needs. We assist them and work with them on that. In this case, the science doesn't even justify it. We did the accommodation to another 100 times below this, and that was unacceptable because they want no smart meter, and that is not compliant with the Act.
And just out of curiosity, what's it cost to move the meter 30 feet straight up in the air?
I don't know if we can do it straight up in the air, Your Honor, but the cost is not, it's not a large cost.
Not exorbitant? All right.
I would like to return to Justice Donohue's questions around depreciation schedule, because that is also really, I think, the statutory question that I know you're concerned about. The issue here is, what does that language mean? Why should we interpret it that way? And I think this is addressed on page 30 of our reply brief very clearly, where the existing regulations mandate a 20-year depreciation schedule for meters. What the General Assembly was doing was setting a timeline. There had to be a timeline to get this done, because otherwise you're never going to achieve the benefits of Act 129. That's what that time is about. That's what that third clause of F2 is about. It is not an annual depreciation schedule. That's addressed in the cost provisions of the statute. But when you look at the three prongs, it's new customers who want it, who want to take advantage of the technology. We all know early adopters. These are those customers. The new construction, because we don't want to be putting old meters into new construction that we're going to have to take out. And finally, getting rid of all the legacy meters by a date certain so that the benefits of Act 129 can be achieved. That's what that clause is about. And there's no other space there for an opt-out. Now, with respect, I've already discussed the full hearing issue, and again, the medical certainty. The record is very clear, and that's what the commission considered, and that's the testimony they heard, and the other side could only offer speculation. And I hope that addressed many of your questions. I do want to move on to the other statutory issues here that I think are of concern.
Counsel, not to beat a dead horse, but I'm going to beat a dead horse.
Please.
As long as you don't electrify it.
Well, that's true. Your explanation of the use of the term depreciation has some saliency in the big picture, but what an obtuse way for the legislature to say, and everybody else has to sign on to this. I mean, it's just strikingly obtuse. And your co-counsel explained to us that did I understand correctly? They're talking about the depreciation of existing meters?
Correct, Your Honor, yes.
Okay, I have to accept, for purposes of our argument, your understanding of what this means, but I can only say that it's a strikingly bad way of saying that, and then everybody else has to sign on.
Well, Your Honor, I can't presume to speak for the General
Correct.
Assembly, of course.
Nor can I. So.
But I would note that that is the coherent reading of the statute. And the other readings that the complainants are offering just don't make sense. You can't have shall furnish, and shall depreciate on another schedule. It just doesn't scan.
And you're going to talk to us about what shall furnish means. Yeah. That's your job. Okay.
But the only other point I would make is while we didn't make it up, Your Honor. While we think it's unambiguous, while we think it's clear, while we believe the commission directed us clearly in orders that weren't affirmed as to how to do this, the complainants raised the legislative history issues, and when you look at it, the Senate legislation talks about a depreciation schedule for existing meters. They compromised on the time period, and that is how we ended up with this particular clause. So, with respect to furnish, Section 2807F2 provides that electric distribution companies, EDCs, shall furnish smart meter technology. And I've already discussed the orders, and I just want to note that per the brief of the Energy Association of Pennsylvania, all of the utilities spoke together here to this court and underscored that there's 5.8 million smart meters at a cost of exceeding $2 billion installed now in the Commonwealth. And the effect of Act 129 was to bring Pennsylvania to join other states that now provide smart meters to 75% of the households in the United States. This is not a new technology. And by the way, one other...
I read somewhere in the record that I think 35 other states have opt-out provisions that they're not challenging.
Those are their statutory provisions.
Right.
And they include...
Well, and you've heard what we think of your statutory provisions, so perhaps there's an opt-out here even though you don't recognize it.
Well, Your Honor, we're working with the actual language. I think in those other statutes you will see clear language, the statutory challenge.
I guess my point being very serious is it does not appear, you mentioned the national experience. It does not appear that in the national experience, the ability to have a small percentage of people who truly feel this is impacting them opt out has caused the electrical grid of the various states to crumble.
Well, that may be a choice in those individual states, but Your Honor, the issue of why this case is so important is if we are at the place where, and this goes to the question of furnish, if we are at the place where utility infrastructure is based on what people feel, or their sincere belief, or what they believe is correct, we are going to have a great deal of difficulty building utility infrastructure in this Commonwealth. We have administrative proceedings that are open and clear, that give people due process rights to make that case, but that can't be the standard. And one other, yes, Justice.
I hate to interrupt you, but I'm kind of on the dead horse that Justice Donahue has over there, and I'm just curious if the consumers in this case were offered the option of having their existing meters starting to depreciate and giving them, in essence, 15 years.
Well, Your Honor, with respect to the existing meters, I think it's also important to note, and this is very clear in the record, PECO's existing meters already had wireless technology. It was only unidirectional. So the idea that we are going to go to meters without wireless technology doesn't take us back to before Act 129.
I guess my question is, did PECO offer those customers the option of keeping their existing meters for 15 years?
No, Your Honor, because we did not. We had a plan that we actually were able to accelerate, and we were implementing the plan as directed by the Commission. But to what I was underscoring was, we previously had meters that we had meter readers. That's not what we had. We moved years ago to automated meter reading with unidirectional capability. Those are the meters that we are removing here. Those meters, in fact, and the record is absolutely clear on this, the wireless transmissions from the new smart meters are less than under the existing meters.
Can a consumer read their smart meter on their smartphone?
Yes, Your Honor, that's the vision. The vision is these meters have particular capabilities. One, they're able to communicate bidirectionally.
So greater monitoring possibilities.
I'm sorry?
There's a greater monitoring possibility by the consumer?
And action. Because the other piece of these meters is, and this is discussed, there's a bidirectional capability of the data. There's also the ability to communicate with devices in your home. Because we all recognize, we want people to pay attention to their electric bills, of course, but we recognize that understanding what may happen on a particular day is hard. But prices to devices is the vision here, that we can have smart meters that understand what's happening in the energy markets so that you can use the technology in your house to save money.
So it's the wave of the future, no pun intended.
And that was really the vision. That was the vision.
Thank you.
So with respect to furnish, what the Commonwealth Court did here was really quite extraordinary. No party had argued this interpretation of furnish before, not before the Commission and not before the Commonwealth Court. And frankly, they had no benefit of the briefing of any party. Furthermore, we believe no party really even relies upon it now. One group of plaintiffs is focused on a very different interpretation of F2, where there's no obligation at all, and the Randalls contend that the Commonwealth Court did not equate furnish with offer, but in fact, that's clearly what they did, as I think the Chief Justice remarked earlier. And as explained in our briefs, the word furnish is used throughout the Public Utility Code, and it means the installation and physical presence of utility plant used to provide utility service. It does not mean offer with a customer right of refusal. These go to the core statutes where you will find this word. Section 102, the very definition of what public utility is, has the word furnish. But it has someone who is not a public utility, is someone who furnishes only to themselves. It can't be that somebody furnishing only to themselves is engaged in an offer and an acceptance. It just doesn't make statutory sense. Similarly, in Section 1102, the phrase is to begin to offer, render, furnish, or supply service. Furnish doesn't mean offer. As the Commonwealth Court, concurring and dissenting opinion, noted, it wasn't the Commonwealth Court's place to create an opt-out provision where there wasn't one. And the consequence of this is really enormous, because if furnish and maintain adequate utility service under Section 1501, or furnishing service upon meter under Section 1507 means if the customer wants it, we have a very difficult time installing, maintaining a system which is fundamentally reliant on economies of scale, on the ability of us to serve large numbers of customers and to install such technology as substations, as utilities. This particular case before you is about smart meters. But if potential harm, sincere beliefs, what customers decide is their best technology, How do we site the next substation?
Why do you suppose that there's going to be some avalanche of these opt-outs?
Because we have them already, Your Honor. There's 70 cases now.
I mean, don't they have a fairly high standard that they need to establish?
That's what we're trying
gain
to
the-
defend here, Your Honor, yes.
Given the economies of scale built into this paradigm here, why do you have a concern that the tide of accommodations is going to rise sufficiently far that it's going to defeat the efficiencies?
If this court, we believe the standard that was applied and that the Commonwealth Court affirmed of the constructual causal element here, we believe that that language is really just a preponderance of evidence that goes to the testimony before, of medical and scientific testimony that was before the court. That's all the commission was assessing. And they say it shouldn't, conclusive is too hard. But if the burden is inconclusive, then it opens the door. If they only have to prove inconclusive causal connection, that is just an impossible standard. And so yes, that's the concern. We have already have 70 pending, others have been dismissed, we have others pending appeal. And what it means is not building just
How many
the old
customers
system.
do you have?
I'm sorry?
How many customers do you have?
1.6 million, Your Honor.
And 70 took an appeal. I can't even do that percentage, but it's 0.000. It's a thousandth of a percent.
Your Honor,
So in the scheme of your business, Justice Wecht is right. It doesn't make much difference.
Your Honor, we are going to have, because of the public nature of our business, if there is an opt-out, we're going to have to make it available to everybody.
But counsel, you don't know, let me just see if I could say this again, because I thought I understand it. What we're talking about when we're talking about moving meters away from the home, that's not an opt-out. To distinguish an opt-out from an accommodation is what this is about, as I understand it.
Your Honor, but the accommodation that these customers want is no smart meter at all. That is not the accommodation. We've already offered the accommodation of moving. They want no smart meter.
And does your tariff have to be modified in order to accommodate that?
The statute has to be modified.
Well, let's talk about your tariff first. As I understand from PUC counsel, you're providing an accommodation as provided in your tariff, which went through the tariff approval process, et cetera, correct?
Well, as I noted, our opportunity to relocate a meter has always been available to customers under our tariff, or it has been available before Act 129. That accommodation is present now.
But
And
why are you litigating them then? If someone
Because-
can ask for an accommodation and you're willing to move it, are you only litigating them because they don't want it moved, they want a complete opt-out?
They want, yes, Your Honor, that's exactly the
If
point.
they say we
You're-
just want a special accommodation, we want you to move it a certain distance from the house, you won't fight that.
Right, Your Honor,
You'll just make them pay for it.
They appealed our views of smart meters. And so
But-
then we're here with the Commonwealth Court.
Along that point, just as a matter of fairness, yes, the consumer has to pay for it, but in this world in which you live, the consumer pays for everything. They pay for the meter in the first place, they pay the rate setter charge, they have essentially no say in it unless they've objected at a public hearing when rates are set or your tariff is issued. So, I mean, this is par for the course.
Well, yes, Your Honor.
And I don't mean that in a derogatory way, that's just the way public utilities work.
Yes, but those costs are socialized across all of our
understand
business.
that.
And I should note, with respect to smart meters, the view and importance of this technology is PECO actually obtained federal dollars to reduce the cost of the installation of its smart meter system as part of the, in the wake of the recession in 2008, when monies were appropriated in the wake of Act 129. So we were actually able, because the federal government's policy is to support smart grids, we were able to leverage federal dollars to reduce the costs to our customers.
Counsel, is it PECO's position the only accommodation is moving the meter?
Your Honor, we need to install the smart meter, so the accommodation is moving the meter.
Okay, so again, let's go back to my theory that if I reside in South Philadelphia in a row home, and 30 feet I'm into my neighbor's kitchen behind me. 30 feet I'm in the middle of the city's street, because that's life.
Your Honor.
How is that an accommodation?
Your Honor, I don't have that in the record with respect to the row home.
I'm asking you as a hypothetical. You're speaking for PECO. You're saying the only accommodation is moving it. I make an objection because I live in a row home in a very isolated area, South Philadelphia. My home, I have a 3-foot yard behind my house. My house is only 50 feet, if that. And I might be of a width of 15 feet. It's the majority of the size of the homes. So 30 feet puts me 2 neighbors down to the left or right, in the middle of the roadway, or in my neighbor's kitchen. I'm finding that somewhat absurd that that's the only accommodation.
Well, Your Honor, in the factual scenario you gave me, I may take the 15 feet, because at that point we'll have lowered the levels 50 more times below the millions of levels they are before the Federal Communications Commission. So I think we'll have achieved what we believe is having installed the smart meter and made a reasonable accommodation. As in this case, the facts are really critical. So we would be looking at what accommodation would work with you based upon the facts. And the facts here are that those would reduce levels well beyond what the FCC has determined. Now, with respect to the FCC, I do want to make this point because it is something that came up while this case was being briefed to the court. As you know, in our briefs, we explained why the DC Circuit's decision in Environmental Health Trust is not relevant. As the court made clear, the DC Circuit made clear that the FCC could reach the very same conclusions with more explanation. That was an Administrative Procedures Act case that they were considering. In that case, they conducted an extensive proceeding and had concluded that its levels were valid and that the RF admissions at those levels raised no issues of concern for human health. What the DC Circuit did was it actually affirmed the commission with respect to the levels that had no adverse human effects with respect to cancer. Okay? We're now dealing with the alleged non-cancerous issues. In doing so, they actually considered the report that the complainants here focus on, the National Toxicology Program report, and explained why that report didn't change anything. Its levels were well above the FCC's minimum levels. So in effect, that decision actually underscores the factual findings here that were before this commission.
What was the burden of proof in the FCC case? Preponderance?
That was a notice, Your Honor.
Okay.
A notice of inquiry there where it's under the Administrative Procedures Act, and it's, has the agency sufficiently documented its findings.
Let me clarify 2 points. The first point, the burden of proof that was used by the commission in this case is a longstanding burden of proof, preponderance of the evidence. Is that correct?
That is correct, Your Honor.
And the standard of review for findings made is the same standard of review that has been applied over the course of decades.
That's correct.
Okay, so in order to accommodate what the consumers want in this case, we would either have to change the burden of proof to something below a preponderance of the evidence or change the standard of review.
Yes, Your Honor. That is exactly the issue, because the conclusive causal connection simply means that the totality of the evidence must support the required finding. That's what that standard is about. Here, that the RF radio frequency has the adverse effects that the complainants alleged. And the record evidence established the scientific consensus that low-power RF transmissions, like those emitted by the smart meters, do not have those adverse effects. Now, they claim that providing a conclusive causal connection is too high a burden, but an inconclusive causal connection is no burden at all. That's not a preponderance of the evidence.
Well, I think what they want is to prove a causal connection. Why do you need the adjective?
But they aren't even doing that, Your Honor.
Well, maybe not.
It's inconclusive causal connection. They aren't even doing that. And in fact, they concede that they can't prove these are unsafe.
May I ask you before you sit down? We've talked extensively about safety, which is one of the 2 criteria for an accommodation, I guess is what it is. The other is unreasonability. Do you have a definition for that?
Well, Your Honor, I think, again, we have to look at the overall facts, but 2 points on that. First of all, we believe the Commonwealth Court got it wrong when it thought the PUC was confused about the disjunctive conjunctive. We believe they looked at both safety and reasonableness. But here, we have to look...
You think they mean the same thing, or that you need to prove both?
they looked at both, Your Honor. You're considering both the safety aspect and the unreasonableness. But the question here is, what is unreasonable? The nature of the unreasonableness here is the complainant's view about the safety of the meters. It falls in upon itself. And what they're then saying is, it's our belief. Because we have this belief, then it's unreasonable for us. That can't be the utility standard. And
Well,
now
nor can it be, I'm sorry to interrupt you, but nor can it be the standard is wait until people die or wait until, serious harmful effects occur. It's hard for me to come to terms with your argument because sometimes new technology takes years before we understand what the negative health impact could be.
Yes, but here we have the best science here before the commission. We have to make decisions. Just as this court has to make decisions at particular points in time, the commission gave everyone a comprehensive hearing. And the Woodburn-Hedon standard, which is here, is just that, looking at the totality of the evidence. So yes, things may evolve, our understanding may evolve, but this is a comprehensive record developed after days of hearings before the fact finder, and they reached their conclusion. Now, I do note that with respect to Woodburn-Hedon, one of the complainants, Povacz Murphy, suggests that the Woodburn-Hedon Commission had prevented consumers from presenting any expert testimony. That's not true. They talk about it in their brief, but the actual site, 78 PUC 486, has the initial decision of the administrative law judge there, and that summarizes over several pages the expert testimony presented about radiation at that time. The commission is not closing off people. They're hearing all of their experts, and they're reaching the conclusion as they are able to do so.
Counsel, before you conclude, your discussion of shall furnish, you don't think it's a pertinent analysis? You don't think we should focus on that terminology at all?
I do, Your Honor. I endeavored to, perhaps I didn't discuss it enough.
Well, I mean, you said no one ever raised it. The Commonwealth Court raised it on its own. None of the parties here actually rely on it. So my question to you is, should we just forget about it?
No, I think it's really, actually very, very important.
Okay.
That you overturn the Commonwealth Court's vision of that. What I was trying to underscore was to explain how we see, and we believe the General Assembly over many years has seen the term furnish, which is essentially...
What I found rather salient is Section 1501, which deals with the safe and reasonable service. It starts with every public utility shall furnish. I mean, that has to have the same meaning throughout the statute, I would assume.
That's correct. And, the word provide is also typically used, but not offer. It's reading that word in 1501 as shall offer and customers shall maybe accept utility service. When utility service, as you know, under the statute, service, the General Assembly is also very clear in the definition. It's a really interesting word. Service is defined to be to the maximum extent possible. And the broadest interpretation is how the General Assembly tells us to look at service. So it means everything under the sun that we do as a public utility. It means we're regulated in every way under the sun, but it also means that everything that we do, that we're furnishing, is part of that utility service. And if customers can pick and choose what they're going to take for utility service, we're going to have a very difficult time doing what we need to do and diluting it at reasonable cost.
Thank you very much.
Thank you.
Mr. Harvey?
May it please the court. I represent Aplts, Cynthia Randall, and Paul Albrecht, husband and wife. I'm going to address... Yes, my name is Steve Harvey. And I'm going to address issues relating to the burden of proof. I'm going to rely on our briefs for many of the issues that have been raised, particularly with regarding to the mandate. And I'm going to defer completely to Ms. Lewis with respect to the issues that she has raised on behalf of her clients that I have not raised or joined in. My clients objected to the installation of an AMI smart meter by their electric utility, PECO, at their home in the Roxborough section of Philadelphia. An AMI smart meter emits radio frequency electromagnetic energy, or RF, comparable to the RF emitted by a cell phone. They objected to this because they don't want to be exposed to any radio frequencies, any RF, at their home. They don't have or use RF devices at their home. And filing a complaint with the PUC in April of 2016 was the only thing that they could do to prevent the installation on their home of an RF emitting smart meter. Their only other choices were permit it or face shutoff of their electric service.
When you say on their home, just so that we can get clear from the beginning, would that include 30 feet away on a pole?
Later, PECO offered an accommodation that would be to move it, but the homes in this section of Philadelphia are similar to the homes in the South Philadelphia section, that they are quite close to each other.
But putting that aside for a moment, your argument is, correct me if I'm wrong, your argument is that you have to that you get to opt in. In other words, it's not merely that you're entitled to an accommodation. That's not good enough for you, right? You want to be able to say that we don't choose to opt into smart meters. We want our legacy meter. Am I missing that?
In a sense, you are missing that. My clients haven't asked for an opt-out. They conceded all throughout the proceedings that there was neither the statute didn't provide them an opt-out. They were told that before the proceedings began that the PUC was taking the position that there was no opt-out. And so they were forced to file a complaint under Section 1501. So they're not seeking an opt-in. They are people, and this is extremely important because it goes to the point about how great would be the effect here. And it may be a point of disagreement between me and Ms. Lewis as to what we're seeking here, but we have always considered this a claim under Section 1501, seeking a reasonable accommodation for these people. And it's not just based on their subjective belief, it's based upon their medical concerns, based on their medical history, and based on their willingness, or their demonstrated reluctance or their demonstrated desire to avoid or minimize their exposure to RF. They don't use radio frequency devices. They don't have them at their home. And that makes them different from virtually everybody else. Virtually most of us are content to take our chances with the possibility of harm from RF.
Counsel, may I just clarify, you keep saying they have no RF devices at their home. Do they have a cell phone that they use outside of their home?
The record reflects that Ms. Randall, who works in the Lehigh Valley, has a cell phone that she carries in her car that she turns on when she needs to use it for an emergency. They do not have cell phones at their home. They don't turn cell phones on at their home. They don't have baby monitors. They don't have a RF emitting device on their computer or the garage.
She works in a hospital, is that what you said?
I didn't say she works in a hospital. She works in the Lehigh Valley, and she is a chemist, and she works for a company in that area.
Sorry, I'm thinking Lehigh Valley Hospital for...
Mr. Harvey, may I ask you, your opposing counsel said to us that the current meter, electric meter, in the Randall's home, presumably in everybody's home, is already an RF emitter, but it's unidirectional rather than bidirectional. So what accommodation are you seeking?
The accommodation they're seeking is to have no RF emitting device installed on their property, on their home or on their property. And why would it not be good enough to just move it somewhere else on their property, even assuming that the property line is far enough away? It's because they wouldn't be able to go to that part of their property. On their home and on their property, they seek to avoid RF devices. They can't prevent it. Their neighbor has an RF emitting device. They go out to the McDonald's or they go somewhere. Those are all chances that they have to take. But their position and our position in this case is that their property and their home is a place where they should be able to control, and they should be able to say, we don't want any RF devices installed on our homes.
Do they now have that unidirectional device installed on their home?
There is an existing AMR meter that is on their home. That is correct, and they would like to have that removed as soon as possible.
What do you put in its place? Something that's wired to the electric company and back?
Well, this goes to the importance and the correctness of the Commonwealth Court's decision. The Commonwealth Court remanded the case to the PUC for determination of what should be the means to accommodate people like my clients, and so that would be a possibility, would be a wired device, or maybe since there's no smart meter mandate, they used to check meters the old-fashioned way. If it's a small amount of people, there possibly could be checked the old-fashioned way, the use of an analog meter. But none of that is before the court, and the Commonwealth Court very wisely remanded this, I believe, to the PUC for a determination of how to accommodate people like my clients. This is not going to be a large group of people because most people cannot credibly say that they don't use any Wi-Fi devices at their home.
Counsel, if I just might clarify this, because, I mean, we're in a court, and the Commonwealth Court is a court, and there was an administrative proceeding where they had an evidentiary hearing. So I think we have to be clear about what we're talking about here. I mean, before the commission, your client has a burden of proof, and what the Commonwealth Court has recognized or suggested is that the PUC has been inconsistent in its application of a determination of reasonableness. So my understanding is that they have been given the opportunity to go back to the commission and meet an evidentiary burden with the preponderance of the evidence that the smart meter technology is unreasonable under the totality of circumstances. Am I correct in that understanding?
You are correct in that understanding.
And when they go back, if what their evidence is, we just don't like it, they're not going to meet their burden of proof. Do you agree with that?
No, well, it depends on what you mean by we just don't like it.
Well, you've explained to us, and I don't mean to be trite about it, they have a belief that may be firmly held that this technology is something to which they don't want to be exposed for a variety of reasons.
They certainly have a sincerely held belief, as evidenced by their willingness to participate in this litigation for all these years.
No question about that. Is that enough to meet the burden of proof of unreasonableness of the technology?
No, it is not, and we've never said so, and it's very clear in our briefs that that's not the case.
What was the evidence?
The evidence is that my clients, that their sincerely held belief is not objectively unreasonable. And it's not objectively unreasonable because there is objective scientific evidence that the safety of smart meters has not been proved. The safety of RF, which we're all assuming to be safe because most of us use these devices all the time, that actually has not been proved. And that's the premise of the FCC guidelines, which were at the heart of the dispute before the ALJ, and they're also an issue in the FCC case. And by that, the 2016 report of the National Toxicology Program, this is a federal agency, is fully discussed in our brief. And as is the fact sheet that I'm holding in my hand, which is cited on page 16 of our briefs. And this fact sheet is still available at the National Toxicology Program. If you go to click on the link that we put in the brief, you'll find it. And it says there that the NTP studies, quotes, question the long-held assumption that radio frequency radiation is of no concern as long as the energy level is low and does not significantly heat the issues.
Did the commission have that evidence before it when it made its first determination that this technology was safe and they did not meet the burden of proof of establishing the unsafeness? in that first proceeding?
Yes and no. The NTP studies had not come out in final form, and this document was not out at that time. However, we, the complainants at that point, introduced the NTP report, the draft NTP report, and were told by PECO's experts that they didn't need to worry about it because it was just a draft. And until it became final, it was something that could be disregarded. Well, and our expert witness, a PhD, Andrew Marino, physicist, testified that was absolutely incorrect. And the correctness of Dr. Marino's statement was absolutely proven, this is covered in our brief as well, because those studies did become final, and they were peer-reviewed, and they have been published. And the fact is that...
So you want to relitigate the safety of the device on remand to the Commission, even though the Commonwealth Court has affirmed the decision of the Commission that your client did not meet the burden of establishing that the meters were unsafe?
No, well, Your Honor, the Commonwealth Court also remanded it to the Commonwealth Court for consideration of reasonableness without agreed.
Different issue. That's why I hate to be a stickler. It's a lawyer in me, okay? But there are burdens of proof, and there is a factual predicate that has to be established before the Commission. And to a large extent, I agree with the Commonwealth Court's determination that the PUC had not been exactly firm in its application of what reasonableness actually is. So they remanded on that issue, send it back to the PUC, consider the totality of the circumstances. That's what would happen if the Commonwealth Court was affirmed on that issue. Are we in agreement?
Yes, Your Honor, and the Commonwealth Court was clear that would be without a determination necessarily without requiring the reasonableness determination under the totality of the circumstances upon remand by the decision of the Commonwealth Court was expressly without requiring proof of harm because of the existence of what I am telling you about, which is the unsettled question about whether RF is ultimately safe or not. And so the Commonwealth Court said, you should go back and you should consider whether it's reasonable, which would include considerations like Justice Wecht raised about how many people this would affect and how would this be something that would even be possible to do without bringing the system to a halt. We believe that that would be possible, and that they shouldn't be required to prove unsafety because they're not going to be able to do that because of the unsettled question. This issue has bedeviled the industry and advocates for more than 25 years. The same issue came up with respect to power lines. Uncertainty about whether or not in that case it's not radio frequency, but it's a different range of electromagnetic energy, could be harmful to people. But now with the ubiquity of cell phones in our modern world and Wi-Fi devices, some people are very concerned about this.
Mr. Harvey, I asked Ms. Tran about precisely what you're discussing, and her response was, in the modern technological world, if we permit a applicant such as your client to prove unreasonability by proving that the state of the science is such that we can't be certain, that there'll be universal application of that and it'll paralyze our utilities. Do you follow that?
I don't believe that to be the case, Your Honor. I believe that when something is truly uncertain and has been the subject of debate in the scientific literature and is inconclusive as the language that I just read to you from that National Toxicology Program fact sheet is, that people it's a basic question of human freedom, whether you should be allowed to not have to accept that, particularly, and we're not seeking a broad opt-out, we're seeking an accommodation for people who go in with medical concerns, with 3 cancer diagnoses like my client, who don't use it at their homes. These are not people who are saying, I just willy-nilly want out of this. They're not using it at their homes. And for that reason, this is going to be necessarily limited, and that it's the right thing to do to absolutely accommodate people like this without requiring them to prove something that scientifically, at this point in the study of science, just we can't prove at this point.
Counsel, isn't the question of the level of certainty, isn't that encompassed within the burden of proof?
Absolutely.
Because what you're suggesting is a standard that would not only impact situations such as this in the Public Utility Commission, it impacts every determination that a trial court makes based upon a preponderance of the evidence when medical or scientific evidence is in question. So
Well,
if we say that uncertainty overcomes the burden of proof of preponderance of the evidence, we're left with no burden of proof.
That's absolutely, I have to absolutely disagree with you on that.
Okay.
And the reason why is because the PUC is not a court of law awarding equitable relief or money damages. The PUC is a regulatory agency. The PUC should absolutely not require proof that somebody is going to be harmed or has been harmed before it requires an accommodation. The possibility of harm, a regulatory agency should be protecting against harm.
What should the burden of proof then be? Are you
Well,
suggesting there is?
the burden of proof is under the PUC regulations, depends on whose motion is. If the PUC had brought a motion,
But this is your motion.
I understand, we were forced, my clients were forced to bring a claim under Section 1501. But if the PUC had said to the electric utilities, we're going to make a motion, and then it would have been upon the burden, it would have been under the regulations that are cited in the PUC's brief and quoted in the PUC's brief, then it would have been on the electric utilities to prove that it was safe. So what I'm saying, for a regulatory agency,
Counsel, what was the burden of proof? Preponderance of the evidence?
yes, preponderance, actually, the PUC said that the burden was to prove that there was a conclusive causal connection by a preponderance of the evidence, which we don't think makes any sense, because there's no such thing in the law as a conclusive causal connection. That's something that came from the Heaton case that the PUC cites. We think that's unprecedented. That shouldn't be the standard in any event. But the point is that we've also argued that.
Well, before you leave that, what's the standard?
What's the standard?
In other words, what do you have to prove by a fair preponderance of the evidence to gain a accommodation?
Under the Commonwealth Court's determination, we have to prove by totality of the circumstances that it is unreasonable. That's what we have to prove, without requiring proof that that harm will be caused, because that's something we can't prove given the circumstances. And if that's the requirement that we have to prove that, well then everybody gets a smart meter.
Just so that we are clear, I'm clear. And I know there's a disparity in argument between you and the other consumers that are complaining. You're not here to argue that the statute does not mandate the universal deployment of smart meters. You're here to argue only that you should have an accommodation if you can prove unreasonability under 1501.
Correct. To be clear, we rely on our briefs. We also think the Commonwealth Court's decision is correct, including the definition of furnish, which we've addressed that in our brief too, and that the statute, the PUC took the position that it couldn't grant any relief because the statute mandates that everybody must receive a smart meter. We've demonstrated, I argued the case before the Commonwealth Court, that that's not correct, that the code doesn't mandate one, that the PUC has the discretion, particularly under Section 1501, to make a determination of what's the right thing to do, and the Commonwealth Court accepted that argument. I'm simply here arguing that I think I've addressed most of the points that I've meant to address today, and if there's the only other point that I would make is that no court anywhere has approved forced exposure to RF in the means that has been discussed in this case, and we don't think that a court in Pennsylvania should be the first one to do it.
Thank you very much.
Counsel, can I just ask one further question on
Yes, ma'am.
the burden of proof? Are you suggesting that we should eliminate the requirement of proving actual harm? Is that your position?
Yes, affirming the Commonwealth Court on the
Instead of-
reasonableness prong.
What would you have us say has to be proven, if not actual harm? A reasonable probability that harm will be caused? I mean, it has to be tied to something.
We've said that for people who hold sincerely held beliefs that are not objectively unreasonable and who have demonstrated that they don't use RF, that under those circumstances it's unreasonable. So if on the reasonableness prong, And the reasonableness prong, we contend that there's no proof that there be proof that harm will result. That what we have proved about the inconclusive nature of the studies on RF is enough. And I just also should add, Justice Donahue, while I remember something I forgot to say earlier, which is that what we're seeing, this ruling is truly sui generis, a term I had to look up since I haven't used it since law school. But we're not seeking for a ruling that's going to apply to trial courts and other contexts. We're not even seeking a ruling that's going to apply to the PUC in other contexts. This radio frequency electromagnetic energy we're seeking a ruling that's specific to this because of the unique circumstance.
But specific though it may be, you're not ruling out the possibility, the real possibility, that a fact finder on a given record might properly deem a particular set of beliefs unsubstantiated, right?
Yes, correct,
right?
Correct, obviously.
You're
yes.
not saying the fact finder lacks that authority.
Yes. This issue has been remanded to the PUC. The PUC has an extraordinarily broad discretion about how it wants to handle this on remand, whether it wants to handle one case or look at multiple cases, or it wants to do rulemaking, or how it wants to approach this. That's what should happen.
We got it. Thank you. Ms. Lewis?
May it please the court. My name is Tracy Sneed-Lewis, and I, along with my co-counsel, Resden Moore, we represent consumer appellees Maria Povacz and Laura Sunstein-Murphy. And I'm in an interesting position in that I disagree with most of everything that all the lawyers that have come before me have said.
It's a good place.
Heart palpitations, increased heart rates, headaches, ringing in their ears, dizziness, anxiety, insomnia, difficulty concentrating, skin rashes, and burning in the skin. These are just a few symptoms that people, like consumers, experience when exposed to radio frequency radiation, RF. These adverse reactions are real, they're documented, and they're supported by hundreds of studies. They present a major threat to people's health, and people who suffer from them have a federally recognized disability. The Department of Labor, the Department of Education, the Social Security Administration, Social Security Administration, the U.S. Access Board, all of these agencies recognize this particular disability that my clients suffer from. Now, you already are plugged into the issue that the General Assembly could not have intended to force people who suffer from these things to accept a smart meter against their will and against their doctor's recommendations. We agree. We think that when you look at Act 129, and we've heard a lot of statutory construction gymnastics, jumping from section to section to section to pin together a mandate that just doesn't exist. And how do we know it doesn't? Something as important as forcing a smart meter that potentially, that causes these symptoms would have been expressly articulated somewhere in Act 129. The section that you've heard a lot about is Section 2807 F2, the infamous Section 2807 F2. You've read a lot about it and you've heard a lot about it. But in the 44 words that are contained in that little teeny section, nowhere does it say depreciation means deployment. It's just not there.
What does it mean? How are we, given your argument, counsel, what meaning should we give to the legislature's use of this 15-year depreciation?
Okay, so shall furnish means, and we didn't even get into that because we don't think that's at the heart of this issue. Shall furnish, in this instance, is related to the three categories that are in little section I, little section 2, little section 3. We know number 1 doesn't exist because that applies to consumers who accept and agree to pay for it. And as the other side has said, over $2 billion have been paid for, consumers have paid for the over 5 million smart meters at a cost of $2 billion. They've already paid for them. Our clients, the people that I represent, didn't request it and don't want them. The second is in new construction. We know that's not the case here because my clients don't live in newly constructed homes. The third section that has caused all of the confusion deals with depreciation. And we believe that that section, while the other side's trying to convince the court that that somehow means deployment, what we say is that that statutory section instructs the commission to put PECO's smart meter technology that's been placed in service pursuant to little I and little 2, on a 15-year at a maximum depreciation schedule and replacement schedule.
But counsel, that sort of ignores combining 2 and triple I. It says, and I know you know this by heart, it says electric distribution companies shall furnish smart meter technology as follows in accordance with the depreciation schedule. So there's a conjunctive there. I mean, and I agree it's horribly drafted statutory language, which is deference to the legislature. But it doesn't just say that depreciate over 15 years. It says shall furnish the technology in accordance with the depreciation schedule.
You're right, Your Honor. But if you take the commission's argument that somehow that language applies to existing legacy meters, that can't be because that statute entitled smart meter furnishing and the definition of smart meter technology, the legacy meters don't comply with that. The legacy meters, while they may be the first generation of smart meters, only communicate one way. And how do we know that? Because PECO's own experts tell us that. Not only do they communicate one way, they're not capable of the type of usage, capable of providing the type of usage data that's required by the definition of smart meter technology. So however you slice it, it just doesn't make sense. I mean, we can do backflips, but it does not fit into something as important as forcing people to put a smart meter, forcing consumers to accept a smart meter.
I want to make sure I understand your position. Is it, because I perceive there was a distinction between your client's position and Mr. Harvey's client's position. Are your clients arguing that anybody can decline the smart meter for no reason whatsoever? Or are your clients arguing that they're entitled to a 1501 accommodation for unsafe or unreasonable?
So it's a combination, Your Honor. We believe that the General Assembly, for one of the reasons that I just said about forcing people to accept a smart meter over their doctor's recommendations, the General Assembly couldn't have attended that. In addition,
that begs the question that I use a cell phone 24/7, it's glued to my hand, and I still don't want this meter.
So in this instance, what the General Assembly reflected in the language is that smart meters would be provided to people who agreed to, asked for them and agreed to pay for them, and in new construction. And the depreciation schedule was just about rate making and about the depreciation of those meters. Now, my clients, in this instance, they don't want the meter, don't think that the legislature intended to mandate everybody, but they also have another reason why that they don't want the meters. And it's not just because they're sincerely held belief. No. Just because smart meters may or may not be safe for everybody, it doesn't mean that they're safe for everybody. And the best example I can give you of this is just because penicillin, the FDA says penicillin is safe for everybody, if you have a penicillin allergy, it's not safe for you. It's just not. And many times people find out that it's not safe for them when they are given it and they have an adverse reaction and they die. or they have some other issue.
Again, to try to put this in legal terms, somebody pointed out we're a court deciding legal issues based upon statutory framework. If I understand correctly, your clients, for their position, are arguing that it's unsafe for them and therefore they're entitled to accommodation under 1501. And you never get to the question that I asked you previously and you didn't answer, which is, can somebody say no for no reason whatsoever? Does the statute not mandate, so I'm free to say, I'm not afraid of RF, but I hate utilities, so I'm not taking that meter.
Yeah, unfortunately, that's a public policy consideration that the General Assembly struck when they enacted 129. And we look at the contemporary. If you think, we don't think that the statute is unclear and unambiguous, but if you believe that it is, if you look at the contemporary legislative history from the Senate, there was conversation between an agreement between the Senate minority chair and the Senate majority chair, bipartisan. And in our era, we don't agree on much, but across the aisle, they both agreed that this was not mandated, and it's reflected in that contemporary legislative history.
But counsel, we don't look at that unless we determine that the statute is ambiguous, correct?
Correct.
Let me ask you about that, because for a lot of reasons, just the sheer scope of this statute leads one to believe that it had to mean something that these smart meters were going to be provided to only people who wanted them and new construction as it takes place. But in order to support my view of that position, Section F1 requires the electric distribution companies within 9 months to file a smart meter technology procurement and installation plan. How would that be possible if it wasn't predicated on the notion that all of their customers would be required to participate in this program? You can't file a plan based upon people who may or may not decide that they want it and they're going to pay for it up front. I mean, how would they ever devise a installation plan within, deployment and installation plan within 9 months if there wasn't a requirement that they consider the provision of the technology to all of their customers?
Well, the statute does not have an express mandate. Where they took their direction was from the Commission's interpretation. And
no, I'm actually talking about the statute itself,
okay,
which requires the electric distribution company shall file a smart meter technology procurement and installation plan within 9 months.
Correct. And so with that plan, companies have contingencies all the time. And they have, and this was not brief, but since you're asking the question, they have contingencies all the time. PECO's parent company in Maryland they provide some RF meters, they provide some non-RF meters. So when you're creating a plan as a company as large and as big as PECO and the other electric distribution companies, these are things that you look at from a risk management perspective, from a procurement perspective, and from a revenue perspective. And unfortunately, the Commission's interpretation of Act 129 was incorrect and led them down a path that they followed willingly.
But that's what I don't understand. I mean, the requirement of filing a plan within 9 months, to me, indicates a clear expectation that the provision of the technology was going to be for the customer base. Otherwise, I understand there are contingent plans, clearly. I mean, that's done on a regular basis. But they had to file a plan, and in order to do that, there have to be some fixed points that they deal with in making the plan. And the fixed point that they have are their existing customer base. Mm-hmm. And believe me, I'm not in any way condoning, as I used the phrase earlier, the obtuseness of the implementation plan, but I think when read as a whole, there is an indication by the General Assembly that this was a mandate for the utilities and for customers.
And I understand your point, Your Honor. And I'll go back to, it's our position there is no mandate. And we point to that if the court were to find that the General Assembly attended a mandate, we respectfully submit that the court must examine that mandate in light of Section 1501 as it relates to safe and reasonable service for these specific consumers, and it also as it relates to federal anti-discrimination laws. Act 129 should not be read to compel a violation of either Section 1501 or the federal anti-discrimination laws. And so when you look at Section 1501, the Commission in Braun versus PECO, that case dealt with smart meters, it dealt with a medical certification from a doctor, and in that case, they found when PECO installed a smart meter against the doctor's order, they found an unreasonable service, and they fined them. They fined them $500.
Can I follow up, counsel, on that well, it's not a hypothetical, it's a case that you just mentioned.
Yeah.
Why isn't that scenario, and others like it, served by the accommodation language? Isn't that the safety valve? In other words, isn't the scenario here the economy of scale that the Assembly sought to achieve, allowing for your clients or others similarly situated or differently situated to make a case for accommodation, rather than the opt-in scenario that you're talking about? Given that if it was an opt-in, there would have been no way for the providers to make a plan. Who would have any idea how many of millions of people are going to actually affirmatively opt in?
I think we have a strong argument either way. We believe that the language, the lack of express language of a mandate supports our position that the General Assembly didn't mean to force people to take smart meters over their doctor's order. In addition to that argument, we think that the Commission's own regulations under their medical certification regulations would prevent them from forcing somebody to take a smart meter over their doctor's recommendations. And then third, the anti-discrimination federal regulations would preclude them from forcing somebody to take a smart meter over their doctor's. So it's a trifecta.
But in all three of your scenarios, you're assuming that in the context of your client in this case, that they can show to a fact finder that they're in need of accommodation.
That's a good question, and it raises what happened in this case. I was not involved in the litigation at that point, but when I looked at the record, the consumers proved a prima facie case.
Actually, is your answer to my question yes? I'm having trouble getting a clear, respectfully, and concise answers. I asked you twice whether I could opt out for no reason whatsoever, and you didn't answer either time. I surmised that the answer was probably yes. I don't know if you want to take a third shot at that, but what I just asked you, which caused me to interrupt myself, is whether your position is under all of your scenarios, which I guess maybe answers my first question, that you have to prove accommodation.
All right.
Yes or no, and then feel free to explain.
Okay. So the answer to your first question, Your Honor, is yes, because there's not a mandate. The legislature did not have a mandate, and you could, if you wanted, if you didn't fall into any of these categories, you could, because you didn't opt in. It's not an opt-out, it's an opt-in. You didn't agree to pay for it, so you wouldn't have to have a meter if you did not opt in. And the second question, if I'm remembering it correctly,
Do you have to, under your scenarios, prove some sort of accommodation, prove a lack of reasonability?
okay, so if this is an opt-in statute and that you don't have to accept them unless you opt in, then there would be no need for an accommodation.
Right.
Mr. Harvey, Attorney Harvey, kind of formulated this so that we would have to have an accommodation, but that's not what we're saying. We're just showing how.
You're saying the legislature didn't require that we accept it, and so we choose not to.
Yes, Your Honor.
That's it.
Counsel.
Wonderfully stated. I couldn't have said it better myself.
Thank you.
Counsel, I have a couple questions. Let me make one compound question. If your issue is raised pursuant to 1501 and you require a hearing pursuant to 1505, what is the burden of proof? Who carries the burden? And is there a rebuttable presumption?
Okay, so the way it is supposed to work is like the Braun case. Somebody comes, PECO knocks on your door and says, we want to put a smart meter on your home. And I say, no, my doctor told me I shouldn't have a smart meter. PECO says, we're going to turn your service off. I say, you can't do that because
Or you say, I just don't want it.
I just don't want it.
Okay.
Right. But if you say, I have a doctor's note, and my doctor said that he's read about it, I match up, I have a pacemaker, and I shouldn't have one. What PECO then could say is, Commission, we don't believe this whole RF thing. We think it's a figment of their imagination. It's not conclusive. So we're going to challenge that doctor's medical certificate. Then the burden is on them to come to the Commission and say, hey, we don't believe this. We think it's, and then they have the burden to bring their experts in, and consumers could be forced, like they were in this case, to bring their experts in. But for people who don't have money, I mean, my clients are not wealthy women. They've endured over 9 years of litigation, countless hundreds of thousands of legal fees. And Mr. Harvey is saying, send it back to the Commission so we can continue to do this. So we disagree with that. So, and the reason why we do is because this is all premised on the Commission and PECO's, it's their premise that their smart meters are safe. And the foundation for that premise is based upon the FCC's 1996 guidelines.
Yeah, but Counsel, I'm still trying to have you answer my question.
Okay.
So your clients file a 1501 concern. They file a complaint with the Commission.
Correct.
Now, what I gather is you're saying the initial burden is on your clients to provide some medical certification indicating that it's unsafe pursuant to 1501, and then there's a rebuttable presumption by the agency, the Commission, to indicate that they have to overcome that burden?
Right.
But you're also saying they don't have to have a medical reason. They could just say, I don't want it.
Let's assume this court finds that it's mandated.
Okay.
129 is a mandate.
Okay.
And let's presume that the mandate permits an accommodation pursuant to 1501 and 1505. To me, it looks like it's providing a hearing for an accommodation. The question or concern is if this court's to go that direction and rejects the argument of the PUC, the question I have is who carries the burden, what is the burden, and is there a rebuttable presumption?
Okay, I can handle that one. Okay, so in that case, assuming there's no mandate, or assuming there is a mandate, and assuming we're in the accommodation realm, okay, and the consumers put forth their doctors, they drag in their doctors and their environmental specialists and their biologists, and they all testify, and they all say this RF is bad for them, they shouldn't have the meter. And then PECO sends in their legion of experts, and they say, we don't believe with them because the science is inconclusive. The Commission then makes the decision. And that's kind of what happened in this case. But, so does that answer your question so far?
Yeah, who has the burden?
So the plaintiffs, or the consumers have the burden. They have to make a prima facie case. Does that, okay.
Yes. And then there's a rebuttal presumption.
And then there's rebuttal. Okay, all right. And so in this case, they did that. They made their prima facie case. They brought in their doctor. The doctor testified, yes, we they shouldn't have this. And in the ALJ's opinion, both cases, they said that they had met their prima facie case. Okay. Then PECO's experts came in and said, we don't believe them. And the Commission said, all right, we believe PECO, we don't believe the consumers. But based upon PECO's main premise, the foundation of its case was built on the FCC regulations, that there are no harms created by non-thermal, non-cancerous harms from RF. And they relied really heavily on that. And that's why we consider the Environmental Health Trust case a game changer. Because what the DC court found is this, and I'm going to read it. They found that the FCC failed to provide a reasoned explanation for its conclusion that RF radiation at levels below its current limits do not cause negative health effects unrelated to cancer. They failed to discuss the implication of long-term exposure to RF pulsation and modulation, or the cumulative effects of the ubiquitous use of wireless devices. They failed to acknowledge or even respond to the impact of RF radiation on the environment. They failed to address the record evidence from hundreds of doctors, scientists, building biologists, individuals, all linking harm to RF exposures from meters like PECO's meter. That's the foundation of their rebuttal evidence to the consumer's doctor saying, we think you should stay away from these meters. The FCC ignored all the data and failed to support its conclusions that its guidelines were protective against non-cancerous harms. And my husband's an electrician. He's tried to explain to me, the different pieces of this. I'm a personal injury lawyer at heart, and I got involved in this case because I saw there was harm. But here's how I explain it, and kind of how the Environmental Health Trust case said it. It's kind of like the FDA is driving a tractor no one has inspected, no one's checked the brakes, and no one has bothered to look under the hood. Anyone who hitches their wagon to that tractor rides at their own risk. Not only do they ride at their own risk, they cannot give any assurances that the tractor or the ride they are taking is safe because no one has examined the safety of the tractor. Until the FCC provides a reasoned decision for its conclusions, its regulations are safe, anyone telling somebody else the FDA's tractor is safe is merely speculating. In this case, PECO's experts cannot say with any real authority their opinions are true and correct. If PECO chooses to ride behind the FDA's tractor, attached to the FCC's wagon, when no one has tested the tractor, they ride at their own risk. While it may have been reasonable for the Commission to accept whole cloth Dr. Davis's reliance on the FCC's 1996 outdated guidelines prior to August 13, 2021, a careful review of the Environmental Health Trust decision illustrates why such reliance is now unreasonable. And we've talked a lot about burdens of proof. In my realm, if testimony is deficient in any manner, it's then incompetent. It's incompetent to prove the burden of proof. So our position is that from a substantial evidence review, which is in this court's purview, based upon environmental trust and the decision rendered there that calls into question these regulations from the FCC's perspective, and we've outlined in our brief how heavily PECO's experts relied on them. I mean, I think I have two full pages of them quoting, everything is based upon the FCC regulations. We believe that that challenges their burden. And this court is entitled, under the substantial evidence review, to render that decision invalid. Now, we've talked a lot about accommodation.
Would you finish up for me, please?
Yes, Your Honor. We've talked a lot about accommodation and why simply moving the meter away from the consumer's homes will not solve the problem. PECO says with confidence to you that removing the meter away from the home is going to solve the problem, but they really can't say that. Installing the meter further away reduces but does not eliminate the emissions that enter the house. The ACD conversion, and this where it gets a little murky for me, but in the Children's Health Defense building biologist report, there is a report in there from a building biologist that explains this more clearly than I could.
Can I interrupt and ask you why we need to adjudicate that? Isn't that exactly the kind of thing that should be addressed on remand, like the Commonwealth Court said?
Right. So, Your Honor, I understand that. But in conclusion, it's our position, this case has gone too far, too long. It's been, you saw the record, and I see a little bit on there were reams of paper in this case. And consumers ask you all to end it now. They've surrendered years' worth of medical records, their telephone records, their cell records. They paid thousands of dollars. They were subjected to depositions. And they fought a long, never-ending battle. And there's no pot of gold at the end of this. It's not a tort case. They get safe electrical service, if you all agree with us. PECO and the commission.
We understand your position, Ms. Lewis. And the only way you get to what you dream of is we hold that there's nothing in this statute that says that it's a compulsory installation of smartphones, therefore you're free to opt out for any reason, and therefore you have no burdens of proof, nothing you have to prove, you just say, I don't want it anymore. And if you prevail on that first issue, then you have your dream. If not, then you don't, and you have to go back to the Commonwealth Court and keep fighting. Our
Except
system's not efficient.
that your argument's in the alternative, right?
It's in the
That's the first argument, and then if we don't buy that, your second argument is about the burden of proof of the medical.
It's a trifecta, Your Honor.
Oh,
And
great.
in this case, I'm going to leave you with
But ADA is compressed within
the
seconds.
anti-discrimination. I want to leave you with one quote, and this is from the Naperville Court, who they were dealing with the warrantless search warrants and the usage of data, collective data. They say, quote, and I'm using, instead of Naperville, I'm using PECO and the Commission. PECO and the Commission could have avoided this controversy and still may avoid future uncertainty by giving its residents a genuine opportunity to consent to the installation of smart meters, as many other utilities have. Nonetheless, Naperville's warrantless collection of its residents' energy consumption data, and in that case it was every 30 minutes, in our case it's every 30 seconds, survives our review in this case. Your Honors, thank you so much for your time, and we ask that you would, let me tell you what we want. Affirm the Commonwealth Court's Act 129 ruling that there's no mandated forced smart meter installation. 2, remand to the Commission giving clear direction to require the EDCs provide non-emitting meters, which are analog meters. They are the old meters that we used to have back in the day that circulated. There was no bi-directional, no one-way. People could, and the issue of tariffs, the tariff says that they can do estimated usage. So I can go out, read my meter, call them in and say I used 50 kilowatts worth of energy. It's not a big deal to do this. Reverse the Commonwealth Court's ruling imposing a conclusive causal connection burden of proof for consumer smart meter safety concerns. Rule consumers may establish utility services unsafe and unreasonable as to them where the EDCs ignore their doctor's medical certifications, and any other relief this honorable court deems appropriate.
Thank you. Well argued by everybody.
Thank you.
We're going to take a hour break, which to round this off, we'll make it 1:25. We'll come back and hear the final two cases. No, we need to do that. Well, this was it's a difficult. Sorry that we kept you all waiting after that morning. I don't know if you were here to see it or not, but we needed to take a break. So try to pay a lot of attention and be rejuvenated for your cases. In this matter, the property owners seek to construct a new deck off the rear of their home, and they applied for and they received a dimensional variance for the from the rear setback line. A neighboring homeowner appealed to the Commonwealth Court, which reversed, determining the property owner failed to meet their burden of proving hardship. We granted allowance of appeal to consider whether the Commonwealth Court erred in finding that the homeowner had failed to prove hardship sufficient to permit a dimensional variance, and to look at whether the Commonwealth Court exceeded its standard of review. So with that, Mr. Aztec.
Good afternoon, Mr. Chief Justice and Associate Justices. May it please the Court, I am Gary Aztec, and I appear on behalf of the appellant in this case. Thank you for allowing us to argue this issue. It didn't seem as weighty as the issues that you heard this morning, but I assure you it has far greater impact, or will have far greater impact upon the hundreds of zoning hearing boards who meet every evening around the Commonwealth trying to adjust such dimensional variances as we're dealing here. So I am going to assume, by the nature of the issue that was taken by this court, that we are not here to revisit Hertzberg. Hertzberg is the standard by which we view dimensional variances. We're here to correct the Commonwealth Court panel's analysis of our case. So the Zoning Hearing Board heard and weighed the credibility of the evidence, made findings of fact, concluding that a dimensional variance was warranted in this case. The lower court accepted those findings and conclusions as supported by substantial evidence, found no abuse of discretion, as was the standard by the lower court, and articulated a thoughtful and detailed opinion supporting those conclusions. The Commonwealth Court's opinion, as you, I no doubt noticed, mirrored the narrative of the lower court, but then concluded with one paragraph, with the conclusion it did not agree. And that appeared to be the standard that was used, which caused some concern on our part necessitating this appeal.
Can I ask you, Mr. Aztec, if you prevail here, is there any reason why all of the similarly situated neighbors, who are also affected by this old zoning ordinance, not entitled to identical relief? I mean, is there any distinction between them and your client?
Well, I think one of the reasons, like the objector here, they already have a garage within 20 feet of the rear yard. Many of the people do have sheds in their backyards, and these are very small lots. So I guess the question is, each case is fact-specific. I believe each neighbor who wishes to encroach upon any of the side yards or the rear yards would be obligated to appear before the Zoning Hearing Board and present the set of facts that support that. Keep in mind, however, as you all know, that you have, this court has distinguished between a use variance, which is a pretty substantial burden, and a dimensional variance, which has been referred to by numerous Commonwealth courts as a relaxed burden. And even in Hertzberg, having to talk about it in depth, many factors go into consideration here.
Should there be are you asking for a modification? Would you like to see a modification to Hertzberg at all?
No. I think it's just fine. I think the way zoning hearing boards view Hertzberg, it gives them the kind of situational benefit. I'm going to, if beg your indulgence, I'm going to cite a case. Our jurisprudence has suggested that great deference be given to findings of local zoning hearing boards, since they are from within the community, understand the sensibility of the community, and can better evaluate whether there is a hardship and whether relief is justified. I think
What
this court
case is that?
I think it's in my brief. I just made.
Oh, you're citing
these are
your
my
own brief.
notes that.
But counsel, that's not the Hertzberg test.
No, that is not
No,
Hertzberg.
no,
This
and
goes back,
But that was a question, because Hertzberg deals with and I don't mean to any way suggest that this isn't a very important issue that your client has, but Hertzberg and cases that have followed it deal with blighted properties and economic hardships and financial considerations that are attendant to requiring a variance. That's not this case. And I guess my question to you is, what precisely is the hardship here?
it is just more than the fact that this is an undersized lot, as the panel seemed to emphasize. So it is an undersized lot. It's actually a half-acre lot in a zoning district that the municipalities determined should be an acre and a half. So the zoning district contains lots that are 3 times the size of our lot. That's number one.
Let me clarify,
Number
though,
two,
first. There are other 150 by 150 foot lots in this area.
Oh, yes, there
This
are.
This isn't an exceptional case. There are other lots of this size.
There are.
Okay.
That's true. Two, it's in a rural area that we're dealing with a rear yard setback now. So what is the purpose of dimensional
But what's
variances?
the hardship? I'm asking you what the hardship is, other than the size of the lot.
Well, the hardship is that they are renovating their house. They decided to, it was an 1,800 square foot house. They decided to add to it and replace a patio and above-ground pool, which was behind there.
But that was
So this is-
replaced a long time ago. The above-ground pool was taken out years before this development was taking place, correct?
That's correct, but the patio was still there.
Okay.
So this was the recreation area. And something, I think what Hertzberg elucidates is that things change over time. That when you are renovating, you're upgrading. You're upgrading your house.
But the Hertzberg involved housing indigent women and their children, okay? I mean, like I said, I'm just suggesting that the context is a little bit different. Let me get right to the point.
Yeah.
Wasn't this hardship, to the extent you could call it that, created by the design of the home that your clients wanted? They could have made the addition narrower and had the same size deck and be within the ordinance, but instead they wanted to use the entire buildable lot for the addition and also have a deck with pillars and steps, headed down to the other property and things. Isn't it the design that created this problem as opposed to anything else?
It did in part, but that's not unlike any other variance. The property owner decides.
But if I could follow up on Justice Donohue's question, doesn't it then follow that to that extent he created his hardship? Right? I mean, in the cases say you can't create your own hardship and then use that to get a variance.
Well, there were other factors that affected his judgment. He was replacing what was an existing patio with a deck. Now, we use Hertzberg with, properties that are blighted, but, remember a house built in the 1960s, some of them may not have even had a patio. But you went from a backyard to a patio to a deck.
But let me clarify that, because I think this is critical, and I think this is where the Commonwealth Court was getting at. I mean, we don't do error review, so the only reason we would take this case is if the Commonwealth Court, did they recognize an error of law here? And I think that's what they are suggesting. Your clients didn't replace a deck with a patio. They took out their existing deck, made the addition to cover what was the existing deck, and then added on to what is now the back of the house to create the new patio. And it's that patio that was part of this expansion design that caused the infringement of the setback requirement.
So, but the zoning hearing board, hearing those facts and hearing no other facts, it's not like the witnesses at the zoning hearing board were subject to withering cross-examination, nor was there any other testimony provided other than the one neighbor who already had a structure within that rear yard setback, complaining about the size of the house. So that's the factual basis upon which the zoning hearing board took this case.
Except the setback for the shed that was on the complaining landowner's property is different than a setback for a structure like your client was developing.
I don't know what the difference is. What's the difference? If it's a large structure that sits 20 feet from the rear yard, and this is a deck appended to the back of a house, a nice new deck appended to the back of the house that is more than 30 feet from the rear yard. So with no one else in the neighborhood objecting except for the neighbor who says the house is too big. That's the facts.
Mr. Astor,
those are the facts.
let me ask you, what did well, I think I know. The zoning hearing board granted the dimensional variance.
That's correct.
Was there substantial evidence on record to support the zoning hearing board's decision?
I would submit that there were, and the lower court, the lower
that
court found that
evidence
there was
was
substantial evidence.
That it was a half-acre lot, and that, I think, didn't your builder testify that this was the minimum deck that would make a deck functional?
That's correct, that the neighbor
hearing
had a
officer-
similar encroachment, that it was a farmland, there was farmland to the rear, to the side, there was a 33-foot wide unopened alley, and that there was no harm to the neighborhood. There was no negative effect upon...
The fact that I would have decided it differently if I was the zoning hearing board and $2 buys you a cup of coffee, I'm in an appellate court.
And that's the point of this appeal.
All right.
That's, and I think let's redirect, because I wasn't here to argue Hertzberg, and the court didn't take the Hertzberg issue. We could argue Hertzberg. We could argue about how relaxed that standard has become before zoning hearing boards. You may take that up some other time. But what we are dealing with here is, what is the standard of review? And the standard of review is the zoning hearing board is the fact finder. There is... The lower court and the Commonwealth court would have to find that it abused its discretion only if the findings were not supported by substantial evidence. There was evidence, and there was no evidence to the contrary. There was evidence. You don't have to like the evidence. The Supreme Court doesn't have to like the evidence, but the zoning hearing board, liked the evidence. And the lower court found that they didn't abuse their duties when they're doing that. So as the ultimate fact finder, they determined the credibility of the witnesses and the weight afforded to the testimony. And they may accept or reject the testimony. I don't have to, you all know that. This is, this is something that we've been dealing with, since law school. And the appellate court errs when it substitutes its judgment on the merits for that of the board. And although I recognize that reasonable minds might differ, appellate judges living in other situations from other areas might differ, but when it comes to Plainfield Township, this neighborhood, the zoning hearing board heard the evidence and concluded that there was justification. Now,
can I jump in there, Counsel? Surely, you're not mischaracterizing the standard of review. The question I have for you is on the legal standard under the municipality's planning code. The Commonwealth Court felt that the first and last of the factors were where the zoning board went wrong, and I guess to distill that, it seems like the Commonwealth Court, at least in relevant part, felt that what your client established wasn't a hardship, but merely a personal preference. And so that would be, if true, that would at least arguably be a legal issue as opposed to a, like violating the standard of review. So can you tell us why your client established a hardship within the meaning of the code rather than a mere personal preference?
There was a unique physical circumstance. I mean, we can go through the checklist of variances from the MPC, from 910.2, but keep in mind, when it comes to dimensional variances, other factors come into play. So we are not necessarily limited to the specific 5 items. One, unique physical circumstances, it's an undersized lot. You can't deny the fact it was an undersized lot. It may have been a perfectly wonderful lot in the 1960s, a little half-acre lot with a little bungalow, 1,800 square feet, that's perfectly fine. In this century, however, in a neighborhood where large houses are being built on 1.5 acre lots, that's a different thing. Because of the physical circumstances, because of the very small building envelope, an unnecessary hardship arose.
I have to stop you there because in responding to Justice Weck's question, I don't think you're explaining how this is a hardship rather than a personal preference. I don't understand the hardship.
The family is renovating a home to bring it into modern standards.
Uh-huh.
Just like if you had a blighted property and you were going to make it new, bring it up to 2021 standards. They added more space and they wanted an outside deck.
Personal preference.
It is, and I am not quarreling with the fact that it's personal preference. You find it's personal preference. That can be a fact, but that doesn't necessarily undermine all of the other factors that go into why a variance from the dimensional requirements of the ordinance are not. Now, keep in mind, a dimensional variance is not like a use variance, okay? So, it allows reasonable use of the property. Reasonable by
So even if it
enlarging
wasn't
it
a
a little
hardship,
bit.
your position is you prevail even if it wasn't a hardship.
I prevail that it is a hardship under the current circumstances. If you're going to renovate a house in the 2020s, that you're going to want to put a deck on it.
So it's a relaxed standard to define hardship.
And it's the relaxed standard that the Commonwealth Court has repeatedly referred to in its opinions about dimensional variances, that they don't necessarily have to follow the rigid standards that we have always done when we looked at use.
And you prevailed, your position is you prevailed when you put evidence of record, evidence on the record at the zoning hearing board, and they bought it.
Which they accepted as true to support the issue. Yes,
I think we understand your position. Any further questions at all?
It's not, you're not asking for a relaxed standard, you're asking for a relaxation of an already relaxed standard, aren't you?
What I'm asking for you to do is not to second guess what the zoning hearing board did. What I'm asking you is not to substitute your judgment for what the zoning hearing board did. That's what I'm asking for, and that's why I say what we do here influences zoning hearing boards across the state, because they're dealing with situational issues in neighborhoods, and when someone wants to encroach a bit, we're only talking about 700 square feet, a little less than 700 square feet now. It's not big. And if you read the transcript, and this is, when I began this hearing, I said we're asking for a de minimis variance. Now, that legal issue didn't carry through, but the fact that it is de minimis is another one of those factors. We're not asking for too much that doesn't affect the neighborhood, and zoning hearing boards ought to be given that kind of latitude. I believe you gave them that latitude. And once they make those findings of fact, once they reach their conclusions, and then the lower court affirms that, I submit that it is not for a higher court to tell them that they're wrong. I think it has a chilling effect on what's happening down on the ground in our communities. And if there's to be any correction, it can be done at the trial court level. It shouldn't have to come up here with appellate court judges second-guessing.
Can I just briefly follow up, counsel? suppose it had gone the other way. Suppose the thing had gone sideways in front of the zoning board. You know, then presumably you'd be here arguing that the zoning board didn't apply the law correctly, and that we shouldn't defer to them. So really, isn't your better argument that the screw up was by the Commonwealth Court on their standard of review, right? I mean, isn't that's really the argument, right? It's not that, because regardless of how weak, so to speak, your case was in front of the board, you won it there. And you want to tell us, I guess you want to tell us that the Commonwealth Court shouldn't look behind that or beneath that. Is that what you're saying?
Yeah, they can't in one paragraph, after reciting the entire lower court's opinion, say, we disagree.
But they're disagreeing with the conclusion of law, not with the underlying facts that the zoning board found. That's where I'm having a little bit of trouble following your argument, in so much as the Commonwealth Court didn't contest or disagree with the findings of fact from below. I thought it disagreed with the holding that hardship was created. Did I misunderstand?
Well, I think the lower court saw undersized lot and preference and really stopped there and discredited the record that we had made to support the fact that that we were justified under the Hertzberg standard in securing a minimal dimensional variance.
But isn't that a conclusion of law rather than a finding of fact? Or disturbing the findings of fact?
Well,
maybe it's mixed.
I don't know. And preparing for this, I was thinking, judges think about those issues far more than litigants do in terms of, where the line is. That's
why they pay us the big
bucks.
Exactly.
It's like the fine line in soft sand that I read about recently. Let's give respect, I submit, to the lower court and to the zoning hearing board, particularly when it comes to dimensional variances, and when they make findings of fact that they believe constitute local hardships, that should not be second-guessed or disturbed.
Well, try not to think too hard about it.
I'm going to leave it to you to think too hard about it.
We appreciate your argument. Mr. Lewis?
Mr. Aztec, members of the court, may it please the court. My name is Ted Lewis. I am here, of course, for the objector, Kneebone, Ruth Kneebone.
Are they connected to the thigh bone? Are they connected?
Oh, okay. All right.
You knew somebody was going to go there.
I have to say I've been a solicitor to zoning boards for over 40 years, and ever since Hertzberg, there hasn't been a dimensional case where the attorney for the applicant hasn't said, oh, it's a Hertzberg case. After all, the standards are relaxed. And I think that Hertzberg is often used, of course, to the benefit of the applicant, but misused because...
But why isn't this an even stronger case than Hertzberg? I mean, that was in a dense part of the city of Pittsburgh with adjoining landowners. Right. This case, you've got a 130-acre undeveloped farm in back. So what was the argument that your client had that allowed the overturning of the zoning board?
Okay. Well, first of all, as far as Hertzberg is concerned, is generally that we talk about the need for financial relief, and there's no need for financial relief here. It isn't that he can't meet, he's got a difficult property, he can't meet the building codes and all the other things unless he gets a 50-unit dwelling, and he can't do it with the 30 units, so please give more so it makes sense to comply. That's more like the Hertzberg situation. Here...
Hardship, it doesn't have to be financial, does it?
I think the key elements of hardship are the 5 things that they talk about, and The financial only comes into being in a Hertzberg situation under certain circumstances. I don't think they apply here because he wasn't being required to spend more money to comply with the ordinance. In fact, he was spending more money because he wanted to go against the ordinance by building a greater area than he would otherwise be permitted to. So Hertzberg doesn't give him any relief here, in my opinion. I think Mr. Astak argues that the judge, the Commonwealth Court says the trial court concluded that there was substantial evidence, and we disagree. That isn't an abuse of standard. That is indeed the actual thing that they should be doing, looking at it.
I don't agree with you at all, Mr. Lewis. It seems to me that the reason this case is here, because it is error review, as I think Justice Weck said to you, is that the Commonwealth Court, and it may just be sloppy language, they put out a lot of opinions, but they said we do not agree. If that's the appellate court standard, we're free to substitute our judgment for the lower courts. And we all know, and you know, after 40 years of doing this work, that we're not free to do that. If there's substantial evidence of record supporting the findings of fact of the trial court, the appellate court is constrained to affirm, notwithstanding that if the appellate court was the trial court, the appellate court might have decided differently.
Okay, well...
Do you disagree with... I think that's pretty black-letter Hornbook law.
I regret that they chose to say that language, okay? However, it should be seen in the context. The immediate sentence before that says the trial court's opinion agrees, says that there was substantial evidence which supports the conclusion of the board, meaning that a variance should be granted. After our review, we disagree with the trial court's assessment. In other words, and Mr. Asdak has continually said we ought to rely on the trial court. This is not a situation where the trial court took evidence. This is a situation where the trial court took no evidence, is no better than the zoning board to determine the factual evidence, but only to review it to see whether there was abuse. At that point, it all goes on to the analysis. If the analysis of the trial court is good, of course, then one can agree that there wasn't substantial evidence. If it's not good, then we can't agree. And I'm saying here that what the Commonwealth Court did, and following that paragraph, was to indicate that really, when you analyze the testimony, and by the way, there was only really one witness, and that was Mr. Pooler, who was the contractor.
Yeah, but your client didn't even show up. She sent her son to read a message which basically said that it would interfere with the view or something like that when they have 130 acres and their house isn't even near the line. So I find it curious that you would beat up on on them for presenting Mr. Pooler at the zoning board when your client didn't show at the board and sent her son to read a letter about open space.
Well,
I don't understand.
I think she did show.
Go ahead.
I think she was not able to speak. I think she had laryngitis. That's my recollection. And then there was a second hearing, and I think she was at the second hearing. But yes, her son was the spokesperson for her. She's an older woman, and she relied upon her son.
I apologize. Did you finish your answer? All I was going to do is going to piggyback on Justice Weck. Your client barely has standing here. She lives to the side of the subject home, and there's no variance sought on the side setback. From her perspective, she's not aggrieved. I don't know if she's aggrieved by some view or not, but we're talking about behind the house. The landowner behind the house, which is a 150-acre farm, doesn't object to this.
Well, Your Honor,
all I'm saying is Justice Weck said she's not a very sympathetic
all case
plaintiff.
law, she clearly has standing as just being adjacent there, too. In addition to that, she, through her son, offered the testimony that this lot was typical of other lots in the neighborhood, including her own and the ones on the other side. So that the quote, undersized lot was really not a unique circumstances. In fact, there have been cases by the courts that have said where you, for example, want to argue that there are steep slopes, that's a general condition in the neighborhood, then it no longer becomes something unique that you can call a hardship. More importantly, though, is what we have to look at here is a house that was there and lived in by the appellants for quite some period of time in the 90s. And then he doubles the size almost of that house. Not enough room, so he then wants to build out on the patio, with the deck. That is what he preferred to do. There is not a shred of evidence.
But
I'm sorry. Justice Mundy?
recognizing that all across the Commonwealth there is hearing zoning committees, shouldn't they be in the best seat to decide what in their community constitutes a hardship?
Well, let me say this. It is the zoning board's responsibility, and when they carry this out, when they fail to carry it out,
You need to stay in front of the microphone.
Then we can't hear.
they should be overruled, forgive me.
Was
So
it
the burden of
unreasonable-
proof,
Was it unreasonable in this case where the variance on the sides of the house were met? And we're talking about 18 feet on the back, when in fact your client had a structure within the 50-foot setback requirement, and the fact that there was the open farmland behind the house? Wouldn't the zoning hearing board be in the best position in that community to make the determination based upon those facts, whether or not it constituted a hardship?
I think they can conclude whether or not it's detrimental. And again, I think this farmland in the rear is the cart before the horse, meaning that there's farmland in the rear, I would agree, is a big factor as to whether or not.
Let's just wait a second.
Fire alarm.
As we look at our court crier.
That's a new thing we have to tell you when your time is up.
Wait a We'll stand in recess and come back when we can. Yeah, we actually do understand your argument, but go ahead and conclude it.
All right.
We apologize for that delay. I've been on the court 18 years. That's my first fire alarm. I kind of enjoyed it.
Pardon me, Chief Justice. I forgot everything during the meeting. Good lawyers repeat everything they've said.
Now, as soon as we conclude, you two can meet with Justice Wecht in the hallway. Go right ahead and conclude.
Well, Your Honor, I have to tell you what I told my worthy opponent here, Mr. Astak. About 10 years ago, I was arguing the case, and I was just like this, except it was late afternoon. I was called to stand up, and as I stood up, the fire alarm went off.
Is that right?
This was before the Commonwealth Court. It was across the street. They were meeting there at that time.
So it's you.
So it's me. Exactly, right. Yeah, I can tell you that fact. I believe that the zoning board obviously is aware of the situation. In particular, they can make a determination as to whether they think it's going to be detrimental or not detrimental. But that does not relieve them of the responsibility of having substantial evidence of the criteria for a hardship. They can't just say, well, because it's not a big deal or because we don't think it's going to be detrimental, therefore we're going to call it a hardship when it's really not.
Counsel.
And in this case, the most important thing, if we go through those 5 standards, we come to that standard that says in order, the hardship must be something that a variance is necessary in order to enable the reasonable use of the property.
Counselor,
Yes.
the Aplts issue granted is whether did Commonwealth Court abuse its discretion.
Correct.
Now, your discussion on substantive evidence, that was decided by the zoning board and upheld by the trial court. The question for us is it an abuse of discretion? Did Commonwealth Court substitute its judgment for that of the trial court? It's not revisiting or reweighing the facts. We found the facts as the trial court found them, as the zoning board found them. So share with us, what was the abuse of discretion?
Okay.
Or not?
And that exactly is what the Commonwealth Court went off on. It said there is no evidence before this court that we find to be substantial that this variance is necessary for the reasonable use of the property, and that is a requirement. Therefore, the board didn't have substantial evidence in front of them, and therefore we disagree with the trial court, who may have concluded differently. And they have a right to disagree. That's what an independent review is all about when you go before the Commonwealth Court, as long as it's on a point of law, like we're saying here. And that is a point of law. They found Pooler, who's the only person that really testified, was really making self-serving statements, or more correctly, statements on behalf
Yeah, but
of...
let me stop you because
Yes.
because I want to finish here, and
Yes,
I don't want to
sure.
go around in circles. But when you say Pooler's making self-serving statements, isn't that the essence of the issue for the person sitting there and listening to Pooler testify and watching his demeanor to decide?
It doesn't have to do with his credibility. It has to do with whether or not he touched the basis of what needed. At no point in time was he ever asked the question, nor did he give an opinion of the question as to whether or not this addition and the variance was necessary for the reasonable use of the property. And I will also add that the zoning board made all kinds of findings of fact, but they never concluded that this variance was necessary for the reasonable use of the property. That's not one of their findings of fact.
Couldn't we all stipulate that nobody needs to have a deck? I mean, by that criteria, almost every house in suburbia has a deck. I admit not with a dimensional variance. But what you're saying, I think, is a matter of law. Decks are not hardships. Decks are just luxury items. And that may be. Same thing could be true with garages, I suppose.
They did not touch on the reason why this extension had to be granted in order to enable the reasonable use of the property. He's been there as a resident. He's doubling his size without needing a variance. And then he wants to also put a deck on in addition. And I might add that, there's been some talk about a shed. But the shed was a variance granted 20-some years ago. Okay,
although you have to take that into evidence with the substantial evidence
I
aspect.
don't think the shed is evidence of a hardship. That's the point.
Yeah,
Whether a variance is
Mr.
given to the property next door or not is not based on whether this property has a hardship.
My recollection is, again, and we get lots of cases ready, so if I'm incorrect, tell me so, that Mr. Poehler's testimony included his opinion as the builder that he needed the dimensional variance in order to put an effective deck on the house, that this was the minimum size of a deck that would work for the homeowners. Is that right?
What he said was, given the design, given the preferences, he didn't say preferences of the owner, but given what I've been told I need to do, this is what I have to do to get a deck. He also adds, particularly since it's a roof deck. Okay? Now, there's no requirement that there be a roof deck. So if he's saying, I need a variance because my client tells me, who I'm trying to satisfy, of course, that I need an addition that goes right up to the end of the building line. I can't get a deck and on that as well without getting the variance. And he tells me he needs a roof. I'm assuming from a construction standpoint it has to be more substantial. I might add, there was talk about the pool being back there. That is not a reason why the zoning board said you can have a variance. They did not say because there was a pool back there. Mr. Hastek hammers that over and over again. They're replacing something. That is not the law, first of all. Pools have a different setback. And secondly, it can't compare to the size of this structure.
Mr. Lewis, we got the case. Your opposing counsel argues, as the issue indicates, that there was substantial evidence of record to support it. You argue that the question of hardship is a question of law, and on that question of law, there is no deference in the lower court error.
Yeah, I certainly don't think the Commonwealth Court, just to conclude, believed that it was applying a different standard. In fact, up until that paragraph, it recited all the same law that you're familiar with, that the trial court is familiar with, as to what the standard of review is. So its decision that I disagree is the independent review that it makes as to whether there was substantial evidence. And the fact that maybe there's a lot of land in the background might be a reason why the zoning board would be inclined to give it. But I also say, there's been some talk here about like the Kneebones. The burden of proof is not on the Kneebones. Yep. The burden of proof is on the applicant. It's their job to present the evidence, and Kneebone has a right, whether we would think that structure, which, by the way, there's a picture of that structure attached
Finish
to
up.
my
Please
brief.
finish up for me. Please finish up.
Okay.
I think we got the case.
And question whether you would want that structure, whether it's any different than if the house itself had been expanded that far, because it's just as high, almost as high, not quite as high, as the main structure. So I would submit to you that Kneebone had the right to object. They had the right to insist that the zoning board apply the correct standards of law, not decide whether there's a farm in the rear or not. And the zoning board, the Commonwealth Court correctly stated that no, only thing shown here was owner's preference.
Thank you very much.
Thank you.
remove African Americans from the jury, allegedly in violation of the United States Supreme Court's decision in Batson versus Kentucky. On appeal, the Superior Court found a Batson violation as the only one of the African American jurors and awarded a new trial. On remand, the defendant appellant filed a pretrial motion to dismiss on the grounds of double jeopardy. The Superior Court affirmed the trial court's holding that Batson violation did not constitute prosecutorial misconduct sufficient to bar a retrial. We granted allowance to appeal to consider appellant's argument, given our recent decision in Commonwealth versus Johnson as to whether the Batson violation should prohibit retrial. That's about right. Ms. Lynn, you go ahead.
Good afternoon, Mr. Chief Justice. Good afternoon, Associate Justices. Mr. Pomerantz, may it please the court. My name is Susan Lynn, and I represent Mr. Derek Edwards in this case. In the rare case where a Batson violation is not corrected prior to trial, this court should hold that the Pennsylvania Double Jeopardy Clause can apply to bar retrial, and that in this particular case, Mr. Edwards' case, that retrial should indeed be barred. Here, the Pennsylvania Double Jeopardy Clause bars retrial under this court's precedential decisions in Martirano, Smith, and Johnson for a combination of 3 reasons. First, the prosecutor here engaged in intentional misconduct when she struck a juror on the basis of race, the Batson violation. Second, the circumstances surrounding that Batson violation, the number and pattern of strikes against African Americans, makes the Batson violation particularly egregious. And third, the prosecutor in this case acted with, at the very least, conscious disregard that the defendant's right to a fair trial would be impaired.
Counsel, with your first statement that it's compatible to the 3 cases which you cited, those 3 cases all are particularly concerned with the introduction or the failure to introduce evidence. This is a pretrial voir dire process for which, in the 3 cases cited, there would be no remedy but to preclude the trial of that individual, the defendant. Yet, in this pretrial Batson, the remedy is to vacate the conviction and provide a new trial, or pretrial seat the juror. Share with me why my distinguishing those facts are not supported by your position.
So if I understand your
The question is,
correctly,
I'll rephrase it. This is a completely different factual scenario. This is a pretrial process for which the remedy is either seat the juror or post-trial conviction, give them a new trial, as opposed to the cases which you cite, which were egregious conduct on part of the prosecutor. Understanding Johnson lowered the level. I'm still not understanding how you support your position with an evidentiary finding or an abuse by the prosecutor's office of evidence compared to the remedy that we already have in play,
Right.
which would be seat and or vacate.
So with all due respect, what you just said regarding that a retrial could be just as ineffective as a remedy, that argument can be used for any Brady violation. That argument can be used for any case in which a prosecutor ignores the trial court's evidentiary rulings and refers to evidence that's not in the record during the argument, which is what happened during Martirano, right? So both Martirano and Smith, what could have happened in those cases is that the defendant in those cases could have simply been granted a retrial, and that could have supposedly fixed the problems that happened in the first trial. But what this court has said, and what this court has consistently said, is that under Pennsylvania's Double Jeopardy Clause, when a prosecutor engages in deliberate or reckless, post-Johnson, misconduct, and that misconduct rises to the level of overreaching, when it is egregious enough that it is not sufficient to simply grant a new trial. It is not sufficient to simply give the prosecutor that engaged in that misconduct a second bite at the apple. That rather, what double jeopardy requires, what the right of the individual to not have to go successive prosecutions that may be constitutionally flawed, what must happen is that in those rare cases when the prosecutorial misconduct is really that egregious, that retrial must be barred.
Well, let me ask you this. in this balancing process for the court, are we to take into consideration the peremptory challenges of the defense? For example, in this particular case, of the total potential jurors, the defense struck 6 whites, 1 African American, and 1 other, being a Latino or Asian. And the ADA struck 7 African Americans and 1 other. So the difference is 1 individual. So are we to take that into consideration in the egregious misconduct of a prosecutor, that both sides took part in what can be perceived as racist play?
With all due respect, in double jeopardy analysis, I don't think that that should be taken into consideration, because double jeopardy, the way it has been interpreted by this case, in this analysis, when it bars retrial, is focused on both the conduct of the prosecutor, the rights of the defendant not to undergo multiple prosecutions, and the idea that the process must appear to be fair to the public.
But is that not failing to take into consideration that if the defense is striking all white people, leaving a majority of black people, that it would only be incumbent upon the district attorney to start striking what's still left of the jurors? How do we not take, if we're taking a jury pool and both sides are striking based upon their own perception of what would be favorable to their position, and if the prosecution is striking African Americans and the defense is striking white, the jury pool drains, and we have no say as to the number of people or the ethnicity of our potential jury pool. So how do we not take that into consideration?
With all due respect, I do not think that it is proper to respond to a Batson violation by the defense with a Batson violation by the prosecution. It cannot be right that racial discrimination on the part of one party is fixed by racial discrimination on the part of the other.
That's not what I'm asking you. I'm asking you that the number of potential jurors, if one side is striking a juror of a particular race or ethnicity, that jury pool obviously is being drained of them. So if the other jurors seem to be of a dominant ethnicity, then there's no choice but to start striking them, because that's all we have. Now, how is that not to be construed in this analysis as egregious racist conduct on part of the prosecution?
So I think that what you're supposing is that there's some sort of ideal combination of race in the jury, I think. And
no, I'm asking from a commonsensical, I guess the question is, as a trial lawyer, when you're a trial lawyer, you only have what's before you. And if I have 10 people, and my opposing counsel, at the 10, there's 6 African Americans and 4 Caucasians, and my opposing counsel strikes all Caucasians, then I'm only left with African Americans predominantly. So when I strike them, now one raises a Batson challenge,
I understand.
and now I'm left with a decision that it appears that I just struck based upon race, as opposed to what's left in my jury pool. And what I find fascinating is that I saw that Superior Court didn't even discuss that.
So with all due respect, I don't think that's what happened here. Like, I can see a situation in which, say, the entire morning panel has all Caucasian people, and defense counsel exercises all of his strikes against all of those Caucasians, and the afternoon panel is all black people, and the prosecutor exercises all of her strikes against all black people in that. But that's not what happened here.
Well, we could be specific. The morning panel had 19 jurors, of which the court removed 6 for cause. The remaining 13 were 8 African American, 4 Caucasian, 1 Asian. The jury selected 6 from 13. They selected 4 African American, 1 Caucasian woman, and 1 Caucasian male. Defense struck 3 white, 1 African American, 1 other. The ADA struck 2 African Americans, 1 whose son was arrested and 1 whose nephew was arrested. From the panel of 13, 4 whites remained. The defense struck 3. 8 African Americans, the ADA struck 2, 1 other remained. The defendant struck that 1. That left us with the new panel of 19, of which the judge struck 2. 17 remained. 5 African Americans, 10 white, 1 Latino, 1 Asian. From that, the defendant struck 2 whites. The ADA struck 4 African American and 1 other. The alternatives, which was 1 white male and 1 African American, were struck, both by the white male by the defendant, the African American by the ADA, which left from the panel of 17, 5 African American ADAs remained, and the ADA struck 5, 10 whites remained, the defendant struck 1 Latino remained. Therefore, in conclusion, the defense struck 6 white, 1 Asian, and 1 African American, and the ADA struck 7 and 1. So it did play out here.
Well, with all due respect, if we look at the afternoon panel and we look at the strike sheet and we look at the order in which people were struck, what we see is the Commonwealth accepting 1 white female. The next juror up was a white male accepted by the Commonwealth. The next juror up was a black female struck by the Commonwealth. The next juror, a black female struck by the Commonwealth. The next juror, a white male accepted by the Commonwealth. The next juror, a black female struck by the Commonwealth. And then every single time in the afternoon, a black juror came up, interspersed with white jurors. The Commonwealth chose to exercise her peremptory strikes on the blacks only and not the whites. It wasn't a case where the Commonwealth only had the option of exercising her peremptory strikes on black jurors. There were white jurors and black jurors presented to the Commonwealth in the afternoon jury, and she chose to only exercise her strikes on the black females.
Well,
that is what the record
truth is,
shows
the
here.
court only found 1.
That is true.
So your argument carries no weight because we're only looking at 1 juror.
With all due respect, the 1 juror was all the Superior Court had to find for purposes of finding a Batson violation. But here, when we are discussing, when we are trying to evaluate how egregious that particular Batson violation was, this court can look at the totality of the circumstances. This court can look at the entire pattern that was demonstrated and the entire numbers that are demonstrated by the record. That is the key to egregiousness when it comes to when prosecutorial misconduct rises to the level to trigger the double jeopardy clause.
Ms.
Yes.
Lynn, I believe my reading is that no court that we're aware of in the United States has ever granted precluded a new trial for a Batson violation. And what comes to mind is the Mississippi case made famous by the podcast where the defendant had been tried 7 times by a racist DA. And the United States Supreme Court vacated the 7th trial result, which was the first conviction, I think. Well, that's not true. There was convictions that were overturned by state Supreme Courts. But even in that, sent it back for an 8th trial. So aren't you really asking us to do something that we've never done and indeed nobody's ever done?
I agree that I have not been able to find a case in which an appellate court or a state Supreme Court has found that retrial should be barred for a Batson violation under the Double Jeopardy Clause. But I would also remind this court that the Pennsylvania Double Jeopardy Clause is more expansive and more protective than the federal Double Jeopardy Clause. That has been the case since 1992 in Smith. And so while the U.S. Supreme Court, in I believe that was Flowers, the case that you're referring to, sent it back for a remand, with all due respect, I wouldn't be making this argument under the federal Constitution Double Jeopardy Clause. I'm only making it under the Pennsylvania Clause because of this court's precedents in Smith, Martirano, and then Johnson. And I would say that many other state Supreme Courts or state constitutions have chosen to interpret their Double Jeopardy Clause coextensively with the federal clause. But because in Pennsylvania we have chosen, or this court has chosen, to interpret its Double Jeopardy Clause more expansively, I think it is now time, 35 years after Batson, when our criminal justice system is still dealing with issues of racial discrimination.
Agree with you.
It is now time for the court to say that, yes, Batson violations can constitute such egregious prosecutorial misconduct that it triggers double jeopardy.
Or can we follow Arizona, and since peremptory challenges are not constitutionally mandated, just do away with peremptory challenge? Follow Justice Marshall's theory that if you want to end discrimination, you end peremptory challenge. What would be your position to that? Because it's only a rule.
I mean, I don't know that I would object to that. That is not the situation that we have here. There are certainly arguments to be said that no side should have peremptory challenges. I understand that. And there are certainly arguments to say that it is far too easy for any attorney to stand up and offer a pretextual reason that would cover up racial discrimination. So I understand the appeal of getting rid of peremptory challenges altogether. But that's not what we have here.
Are you suggesting that we bar retrial for every Batson violation? It would certainly have a chilling effect on prosecutors violating this.
It would have a chilling effect on that. It would also cause trial courts to be far more vigilant when they evaluate Batson challenges. There is certainly a logical basis for this court to find such a bright line rule, and PACDL, the amicus, do advocate
You're
that.
seeking that bright line rule?
I, on behalf of Mr. Edwards, am not necessarily seeking that bright line rule. On behalf of Mr. Edwards, I submit that the circumstances of the Batson violation here, the number of strikes exercised against African Americans, the order and pattern, especially in the afternoon panel, of how those strikes were exercised, that makes this particular Batson violation egregious enough that double jeopardy protection should be triggered.
Therein lies the rub, and I have no idea what the vote's going to be of the court. How do we define what is enough?
What is egregious when it comes to Batson
Right.
violations? So this court has previously held that a totality of the circumstances test is appropriate to determine what becomes egregious enough to bar retrial. Frankly, in the Brady cases, in the cases where prosecutors ignore the rulings of trial courts, it essentially becomes a totality of the circumstances test. I think the same kind of test can apply here. The court can look at the number of strikes that were exercised against a protected class. The court can look at the total pattern and the order with which those strikes were exercised. The court can look at the reasons that were proffered and how, frankly, implausible they were. I think
Wait, can I just interrupt and ask you then, counsel, in response to the Chief's question, are you saying there's some hierarchy of Batson violations? There are some that are more egregious than others? If that's the case, then what is it about yours that makes it more or less egregious than others?
I think that we must acknowledge that all Batson violations are very serious. It is the intentional striking on the basis.
See, I thought that was your argument a second ago, but because, okay, let me go back to the follow-up on the Chief's question. So, is there a pernicious unintended effect of your argument? If we rule in your favor, then presumably all Batson cases are barred under double jeopardy, and then isn't the unintended effect that trial judges aren't gonna record Batson violations, and then you've actually undone the result you're looking for in writ large?
So I don't think that there's any risk that trial courts will not record Batson violations. If trial courts find a Batson violation, they can fix it right then and there. Jeopardy never attaches. What a bright line rule would do is encourage trial courts to be particularly vigilant prior to jeopardy attaching about fixing Batson violations. Now, the question about whether or not there is a difference between a Batson violation and a particularly egregious Batson violation, I admit is a tricky one, and I would submit that all Batson violations are serious, but recognizing that this court has previously said that only in the most egregious and rare of prosecutorial misconduct cases should retrial be barred, then what I am suggesting here is that in Mr. Edwards' particular case, there are enough surrounding circumstances for this Batson violation, even though only one was found by the Superior Court, that there's enough in the record to show that during the entire afternoon voir dire, that the prosecutor was striking on the basis of race. And because there is enough outside of that single Batson violation found by the Superior Court, which is all the Superior Court had to reach, by the way, because there is enough of that other evidence on the record, that the Batson violation here is more egregious.
In making the determination whether it's offensive enough conduct to justify the remedy that you're seeking here, would it be appropriate to look at the body language of the juror involved? Because I note from the trial court that the rationale that the trial attorney gave for striking this particular jury was that we look at the body language a lot. This juror was sitting back, with her arm kind of against the gallery, as she seemed she didn't really care to be there, and she wasn't really engaged in her Honor's questioning. She caught my attention because she was different than everybody else. Her body language to me felt guarded, and I remember her being somewhat cavalier or flippant with her answers, just in the attitude, the way she delivered them. And I thought, this person doesn't seem like they want to be here, and that they wouldn't be an attentive juror, someone who's going to listen.
So that reasoning offered by the trial prosecutor was the same reason that was analyzed by the Superior Court in the first direct appeal. And it was the same reason that the Superior Court in the first direct appeal found to be not plausible and pretextual. And the sad truth of the matter is that oftentimes body language, or in the case of Snyder v. Louisiana, the Supreme Court case, where a prosecutor says that I struck the person because they seemed nervous. Well, an appellate court can look at the entire record, and the appellate court doesn't have to follow the factual finding or the determination of the lower court. Appellate courts aren't rubber stamps. If there's enough in the record to say, to show, to demonstrate, and to support the conclusion that that was a pretextual reason, that body language was pretext.
How do we determine that, though? How would an appellate court determine that it was a pretext?
The appellate court here, the Superior Court, did indeed do that.
But how? How do you, intellectually, how does an appellate court get to that conclusion?
Here, what the appellate court did was they looked at the entire record. They looked at the pattern of strikes, they looked at the numbers, and then they also looked at the fact that the body language reasoning offered by the prosecutor, frankly, could apply to almost any juror that's called.
Let's discuss that. The concept of a race-neutral explanation, the rules, our lower courts have indicated, quote unquote, has to be rational, reasonable, not implausible, silly, or superstitious. The concept, the purpose of a peremptory challenge is it gives lawyers an opportunity to feel whether they're going to connect with the juror. So that if one is answering in a demeaning way or condescending way, that's for the lawyer to say, I don't think she would be a good juror. She apparently doesn't like me. Or they favor this. It's to get to those issues, just like our jury instructions. Look at the demeanor of the witness. Look how they testify, whether you have to judge. This is a credibility decision. The concept of for cause is obviously as it is. That's why we have unlimited. So I find it interesting, and share with me Superior Court's points for finding Batson challenge, or for finding the abuse here, was one, the explanation regarding Patrice Johnson, that the court, the attorney thought she was not attentive and would not be competent, or what was the language? She would be fair and a competent juror based upon what he perceived as her body language, ignoring him or her. The second, which I found astounding, was that the strike sheet the court's tip staff prepared listed the race and gender of prospective jurors. As a trial lawyer, how would one defend against a Batson challenge or argue Batson if they don't write down the gender and race of a juror? I don't believe there's a trial lawyer, at least in Philadelphia, and I'm guilty of this myself when I tried juries. You knew as a prosecutor you were going to be Batsoned, and you knew as a defense attorney that I may Batson. So I'm tracking the race. Yet the Superior Court now wants a trial strategy necessary work product to be used against the Commonwealth. I find that fascinating.
So I actually am not certain that that's what the Superior Court said. The Superior Court was relying on the tip staff's recording of
It said the Commonwealth
race.
could see it. The point is that we're keeping track of race and gender because that's the essence of Batson. We want to rid our system of race discrimination, systemic discrimination. We're all for that. The concept that I have, and this is almost philosophical, how else can we keep Batson, how else can we keep our jury pool pure if we're constantly embedding race-conscious attack into it? If we were to, we're the Supreme Court. We are the guardians of the judicial system in Pennsylvania. And before us today is a decision whether we want to still embed the fabric that attorneys are racist or jurors come in with racist intent. And I find that revolting. So the question becomes, we're here to pick a proper jury. Tell me, how are we to pick a neutral, what neutral, non-ethnic, race, religion, or gender act is sufficient now if we were to support this Superior Court's opinion?
So, one, I think it's totally appropriate for the record to reflect what the race and gender of jurors are, right? Like, I think it has to.
I think it does.
Batson.
Superior Court used it as a factor to find racism. Didn't they say this was an absurd result or something? I forget the exact words they used. I thought the wording was harsh.
I think that what the Superior Court may have been saying, and obviously the Superior Court's opinion speaks for itself, is that the indication of, I think they may have been commenting on the prosecutor's reliance on those notations in making her strikes. Now, I admit, maybe the Superior Court doesn't actually say that, I'm reading into it, but.
Agree with you.
But what I think is the essence of the Batson violation here that the Superior Court did find was the pattern, the numbers of the strikes that were used against African Americans, the pattern with which they were exercised, and the implausible reason that was offered. Remember, the reason offered by the prosecutor in the first trial during voir dire was that this particular juror was sitting back during voir dire and then looked like she did not wish to be there. And what the Superior Court said, and which I think that as trial attorneys we all know, is that one, if a trial judge tells you sit back and relax, you're gonna sit back and relax. And two, no juror actually wants to be brought into City Hall or the CJC for trial. They don't wanna be there. And so it's perfectly normal that somebody doesn't seem like they want to be there. Now the question of how do we purify our jury selection process, I think ultimately it's not dependent on what the racial composition of the jury that's seated is.
I agree.
It is dependent on how individual lawyers exercise their strikes. And if there is evidence, as there is evidence here, that in striking folks, no matter who the options were, but if it looks like from that record that a prosecutor deliberately struck every single potential black juror from the afternoon panel, and that there were other options, other white folks that they could have stricken as well, that's evidence of both one Batson violation and an egregious pattern. We can't fix race by ignoring race. We can't hide our head in the sand and pretend that every time somebody says, that juror looked nervous, I don't feel like I can connect to that juror who is not of my race and doesn't look like me.
Do you try cases
that can't
as
be
opposed
it.
to doing just appellate argument?
Excuse me?
Do you try cases
I do.
as opposed to just doing appellate argument? Haven't you ever had the experience where you've had a juror that you look at, they do not give you good vibes, they sit back, they seem disinterested, they use their body language to communicate to you that I do not want to be here on this panel? And do you think that you're now precluded under this, the facts of this case from striking that person?
I do not think I'm precluded from striking that person. However, if that's my reason for striking 4 black people in a row, then I think a court can question the veracity of the reason that I've just proffered.
Counsel, could I follow up on that? Because as I understand it, the Commonwealth didn't seek aliquot.
Correct.
You won that in the Superior Court, and for whatever reason, the Commonwealth, so we're pretty far afield. I'd like to bring you back to the case in front of us, and I'm still not clear on whether you're suggesting there should be some hierarchy of Batson violations such that some of them preclude retrial on double jeopardy grounds and some don't. Or are you saying all of them do? Like specifically, what's your position on that? Because if it's some subset of Batson violations, that seems like you're really slicing the salami awfully thin. And I don't know how we're going to have a principled dividing line, but maybe you can convince us.
So, Justice Wecht, I would love it if this court found that there was a bright line rule saying that all Batson violations that are not corrected prior to trial should result in the bar of mistrial, a retrial bar. However, I don't think that I would be doing my client justice if I took that position here, because I recognize that the court is reluctant to exercise that remedy. There is justification for such a bright line rule, and I would remind the court that since Batson was decided 35 years ago, there have only been 23 instances of post-trial Batson violations that had to be corrected on appeal. So the universe of the cases that we're talking about is small. And that if the
consideration that post-conviction relief act cases in which the ineffectiveness for not raising the Batson is, there's a plethora of those.
I don't know that they were, I don't know that they've been found to rise. I don't know that they were, relief was granted. I don't know that relief was granted in those cases.
Ms.
I'm
Lynn,
talking
why
about
don't you
cases where relief was granted.
answer Justice Wecht on hierarchy of Batson violations necessitating dismissal or new trial, and we're going to wrap this up.
So I think that on behalf of my client, I must argue that there are indeed some Batson violations that are more egregious than other Batson violations. And I get that it is hard to draw that line, but that is where the totality of the circumstances come into play here. And in this case, it wasn't just, there was one Batson violation found by the Superior Court, but courts don't find ever that more than one juror was struck. They reach one, they find that one juror was struck on the basis of race, and then they move on. They order the retrial.
Counsel,
because there is evidence here that more than one juror was struck on the basis of race, I do think that that makes this a more egregious Batson violation than if there was only records supporting a single juror being struck on the basis of race. And I get that it is uncomfortable to ever
Counsel,
say.
can I just make sure that I get my question in before we're shut off on your argument? Because I'm troubled by this notion that one intentional decision to strike a juror because of his or her race is not egregious. And I mean, I understand and that may be true. I mean, you know, my colleagues may think that it is not, but that's a very hard argument to make from your position. And making the argument that, oh, some Batson violations are worse than others, leads you down the slippery slope that led to the arguments that the Commonwealth has made in this case. Oh, he was so guilty, we really didn't, you know, any juror would have convicted him, and it leads you down that road that we start looking at an underlying decision of the Superior Court, which is final law in this case. We shouldn't be talking about that at all. As this case stands, there was a finding of a Batson violation, which is an intentional act. And so this notion that there are variations on the theme of an intentional deprivation of a defendant's equal protection rights is one, to me, that I just don't know how you parse that. I just don't know how you parse that.
I would not argue against a bright line rule, let me put it that way, saying that anytime there's a Batson violation that is found by an appellate court, that retrial should be barred under the Double Jeopardy Clause. I cannot argue against that. I think that is a perfectly principled rule. If, however, there are justices on this court that are uncomfortable with that, I would submit to those justices that there is a basis in this particular case, under the facts here and the record here, to find that there was more than just a single juror struck on the basis of race, that there were multiple jurors struck on the basis of race. So I do find myself, I guess, trying to appeal to as many of you as possible for this particular case.
Counsel, you're not going to have the opportunity to do a response after we hear from the Commonwealth. So I would like you to address the analysis of Johnson that was set forth in the Commonwealth's brief, where they break Johnson down into three particular factors that must be answered in a certain way in order to have Johnson come into play. And along those lines, one of the things that the Commonwealth spends a tremendous amount of time on in its brief is what they refer to as society's strong instance in bringing the guilty to justice, which is where they make something of a harmless error type of argument about how strong the evidence was in this case of the defendant's guilt. Does Johnson require this dissected analysis?
No, with all due respect. I do not think that the evidence of innocence of a defendant should ever be at play in this analysis. Our constitutional rights are not meant only to protect those who can prove that they're innocent. They're meant to protect all of those who are accused of a crime. To demand that the defendant here provide evidence of his innocence in order to receive the protections of double jeopardy, in a way flips the burden on its head. And we should remember that while the Commonwealth cites to all the convictions in this case, those convictions were the result of a trial that everybody now acknowledges was not fair and was not constitutionally correct. So I don't think that evidence of innocence could be a factor that this court should consider. Now, with regards to balancing the countervailing societal interest in prosecuting those who commit crimes, the court has already struck that balance by limiting double jeopardy relief only to those cases where prosecutorial error rises to the level of prosecutorial overreaching. We are not saying, I am not taking the position that any single prosecutorial error, every single prosecutorial mistake should result in the double jeopardy clause preventing retrial, only in the most egregious of cases. So that is where that balance is struck. And then finally, I have to say that the evidence in this case is not as overwhelming as the appellees describe in their brief. Yes, there were 8 bills that were brought. Of those 8 cases, only 4 complainants actually came to court and testified. Of those 4 people who came to court and testified, none of them made an in-court identification of the defendant. Only one of them had made an out-of-court identification in a photo array, never even an in-person identification. And we have to remember, all of the complainants who testified described 2 perpetrators, and 2 people had already confessed to this crime. The Commonwealth relies on the out-of-court statement of a co-defendant who they then called as that witness, and that co-defendant on the stand under oath at trial denied the truth of the out-of-court statement that the Commonwealth was relying on. Maybe there was sufficient evidence, but it was not overwhelming. And remember, all of the other double jeopardy cases that this court has analyzed, has addressed, there was sufficient evidence, but the court still found that the prosecutorial misconduct in those cases arose to the level where retrial should be barred. And that is what the court should conclude in this case as well.
Anything further? Thank you very much, counsel.
Thank you.
Mr. Pomerantz?
Thank you, Your Honor. Thank you, Your Honors, first for having postponed this argument for my health reasons, and thank you to Ms. Lynn for having been so gracious about it. There are so many different ways I can go into this argument, but Justice Donahue, I think you want me to talk to you first, because you want to talk about degrees of Batson violation. Correct. And I think you want an answer from me, and I'm going to say to you, yes, there are degrees of Batson violation. There are some that are more egregious and some that are less egregious. Why do I say that? Because Your Honors all the time will address intentional prosecutorial misconduct, and you'll decide, is this a J. Smith or is this a Moose? Is this a Hughes? You are, part of your job is to determine whether something is so bad that it stinks to high heaven and that we shouldn't get a second chance. But the other answer to your question, I believe, is that double jeopardy, as you well know, starting from Strouder versus West Virginia and Powers versus Ohio, double jeopardy is not just a right that belongs to a defendant. Double jeopardy, a violation of double jeopardy, a violation of equal protection in a Batson strike offends the jury pool and offends the public's perception of the fairness of justice. So if Your Honors were hypothetically to decide that there's a double jeopardy violation here that precludes retrial, I suggest to you that you would not be vindicating the rights of jurors to serve fairly on this case, nor would you be vindicating society's perception of fairness. Another thing, Justice Donahue—
Why is that, counsel? Saying it doesn't make it so. I mean, you know, we're looking at a double jeopardy violation, as we always do, from the, in this context, from the perspective of what the prosecution has done or not done in a case. And the prosecutor is a minister of justice. And so in this context, with this defendant or any defendant in a Batson challenge like this, we're looking at the prosecutor's role as a minister of justice in bringing this particular defendant to trial with his equal protection rights in place. So while those other factors certainly are recognized in Batson and in subsequent case law as to what else Batson can protect. In a case like this, when we're looking at the double jeopardy implications, are we not looking at the impact on the defendant's rights?
You are absolutely looking at the impact on the defendant's rights. But you also, Justice Donahue, talked about my brief and what I focused on. With regard to my point about society's interest in bringing the guilty to justice, I didn't create that language. That's language that comes from the court's opinion in Kareem Johnson. And more than once, the court goes back and says, and I think you were all engaged in a weighing process, you say, well, we've got really egregious conduct here in Kareem Johnson, but we need to assess that against other factors. So, I think I overstated what I said about innocence or guilt. I really don't think that's where this decision lies. But I do think that there are other interests that are served by the grant of double jeopardy relief beyond defendants.
But you're arguing then that we, sitting in the situation that we're in right now, have to look at this and say, was the evidence sufficient to convict this defendant, even though the jury was not composed of a community of interest that was capable of meshing all of the different interests that communities bring together in the jury room, because any jury would have convicted him given the strength of this evidence. I mean, it is akin to a harmless error kind of analysis, which sort of struck me as odd in the context of an intentional violation of a right by a prosecutor.
Well,
why would we look at that?
I don't want to be in the realm of harmless error. I do want to be in the realm of discussing the effects on the entire system rather than just on the defendant. And one of the things that I think this court found was really important in Kareem Johnson was to say, the prosecutor in that case said, look at the hat, look at the DNA, this is the case. Without this, there is nothing. And I think that's what Your Honors said about that case. There was nothing without that, and the prosecutor hammered on the podium repeatedly and said that that's what this case is.
It's the falsity of the evidence. It was the emphasis on the wrong cap, and that was the predicate for, that was the problem. That was why it was so egregious. Whereas in this case, we're not offered, so far as I can tell, some basis for delineating between different subspecies of Batson violations. The Batson violation, whether you like it or not, is law of the case here, right? It's a law of the case. So it's wrapped up, it's in a box, there it is, right? So how are we supposed to say something other than it either is or isn't double jeopardy, i.e., how are we to say, this Batson, that's pretty bad, but not too bad, whereas this one is so bad that we're going to say, because we're not just writing for this case, we have to have a standard, right? So what's the standard? You're telling us Batson is never going to be double jeopardy? Is that what you're telling us?
Not quite. Chief Justice Baer referenced the Flowers case. It's a case I cited in my own brief. The Supreme Court was not asked to consider on the 6th retrial whether that was bad enough, but I'll tell you, I don't think my office would take the position of trying to defend that case. I'm not unintelligent, and I'm not going to suggest that there couldn't be a case where it wasn't manifest through the prosecutor's repeated conduct. There isn't that argument with respect to this prosecutor. I also want to make a point, and I don't want to push this point too far, but Your Honors probably read the Bazemore decision, in which the one time a Pennsylvania appellate court has ever considered this question. And what the court said there was, essentially, why are you assuming that this one strike is a proxy, that race is a proxy for how someone's going to vote? This also comes out in Powers versus Ohio. What the defendant has the right to is a fair jury. And what Powers says at a certain point is, we don't assume simply because a person of the same racial identity or religious identity is removed that was the linchpin and that was the juror without whom the jury wasn't fair. So what I wanted to say to you about Bazemore is the court said in a certain sense, to find that this defendant could not have had a fair jury because X juror was not on it is in a sense to rely on some of the same stereotypes that form Batson.
But it's too late in the day to argue Batson was wrongly decided.
It's too late for me to challenge the Batson finding here. It is. But it's not too late for me to say that Kareem Johnson, remember your aliquota grant was under the reasoning and rationale of Kareem Johnson does double jeopardy apply and preclude retrial. So the reasoning and rationale of Kareem Johnson are very heavily entrenched in how bad, how egregious was the conduct here, which is what I hope to discuss.
Mr. Pomerantz.
I'm sorry?
I was in dissent in Johnson. It doesn't matter. It's the law of this court. But here's the difficulty, and we face this continuously throughout Pennsylvania, where we find that prosecutors want to push the boundaries to try to get the conviction somewhat at all cost. And because the worst that happens if you engage in Batson violations under the law of the United States is that you get a new trial. Why not, if you're a prosecutor and you have a weak case and you want a peculiar jury, why not push that envelope? What's the worst that happens? You come back and do it again. And we find that with multiple different questions with prosecutors who sort of rely on due process in trials. So in terms of bringing that then to the question before the court, what did your colleague have to lose, except you have to do it again, in your big jurisdiction trying tens of thousands of these things? And so should we put a stop to that by saying Batson's 35 years old? The Philadelphia DA's office knew better. The Philadelphia DA's office violated, not to protect this defendant, I don't even know his name, but to protect all the citizens of the Commonwealth. We should say if you violate Batson, you don't get a second strike.
I would say that it's not, there could be a time where you reach that conclusion, but this would be a particularly poor case for you to do that. And that's not, I mean, I'm not pulling that out of thin air. The Batson violation here was not found by the trial court. The trial court, you know, the anomaly of this case, is, as I know you're aware, was that at stage 2, the prosecutor explained her strikes, and the court found no problem with any of them. Defendant didn't ask the court to proceed to stage 3. The court didn't proceed to stage 3. So what we have is the Superior Court's finding that they're troubled, well, as Justice Docker, you said, the jury sheet. That's one of their 3 tent pegs.
Doing it again.
I'm sorry?
That's the. I don't quarrel with you that it seems like a very thin Batson violation, but you didn't come to us and seek aliquotter, so it is the law of the case. It is. We can't look underneath and say, you know what, now we're going to question that. It's a Batson violation, period. And that's why I keep coming back to this, you know, how are we supposed to articulate a standard one way or another? I mean, and given that there's a Batson violation, if we don't reverse in this case, are we giving the lie to all that lofty language we always read about the values that Batson's supposed to vindicate, right? About how we subvert the process if we, have a racially skewed voir dire. I mean, what is it about this case that is just not egregious enough, whereas in some cases it might be egregious enough?
I think I can articulate that. And I also, as I said before, I think you do that all the time with other types of deliberate prosecutorial misconduct. So I don't think I'm asking you to do something that's outside your purview. When you consider the fact that the DA accepted 6 of the first 8 African Americans, and the only 2 that she struck were one who had a nephew that was accused of a crime and one who had a cousin, or I don't remember, a son who was accused of a crime, that starts to factor into what you think about what the prosecutor was doing. Now, my opponent made an excellent argument, and she's been nothing but gracious with me, but part of her point in her reply brief was looking at what the Commonwealth did in the first panel and using that as evidence of animus that existed throughout the case. And what she was talking about was 3 jurors who had family members who had contact with the criminal justice system. And she said that that some way demonstrated racial animus by the prosecutor. Those were all 3 African-American jurors, and the prosecutor accepted all 3. So I suggest to you that I can't say anything about the Batson violation, of course. There was the finding of 1 Batson violation. But the idea that the animating principle of this prosecutor throughout the trial was throughout the jury selection process, was discriminatory at all points. This is a weak read for you to rest a decision as big as what's being asked of you here. There could be a case. It's just that this isn't that case.
Counsel, can I ask you a follow-up question on that? Because as you could tell, we've given this a lot of thought. But let me tell you what drives me on this. We keep talking about, Batson said 35 years ago. Batson was only reaffirming a United States Supreme Court that was decided 130 years ago that said, what still goes on in the courts of this Commonwealth today is a violation of the rights of defendants. It's been going on 130 years. So, at some point in time, somebody has to figure out how to stop it. And, on one side of the coin you have, well, it doesn't happen very often, so why mess around with it because it's not that big of a problem. But the other flip side of that coin is it shouldn't happen at all. And if what we are doing is presenting another 27 cases to to go forward to a jury that's based upon an improperly selected jury, maybe that's the right thing to do. If it's not an issue of a double jeopardy violation, do our court supervisory authority give us any ability to interact in this area to call a halt to this?
Well, I think Justice Doherty suggested one. I mean, this is not something I've given a tremendous amount of thought to, but you could eliminate peremptory challenges.
And that would be across the board. In Arizona, they eliminated peremptory challenges in civil cases also. Because Batson applies in civil cases in addition. But I can tell you what the rationale was behind the Arizona Supreme Court's decision along those lines. But aside from doing away entirely with peremptory challenges, which is in a way throwing the baby away with the bathwater, because there is an art to jury selection that in a lot of circumstances requires a nuanced reading of a juror. But that's water under the bridge in this case because we have a Batson violation found in this case. Is there something else we could say? If it's not on double jeopardy grounds, could this court just say, based upon our general supervisory authority, we are ruling that in the case of a Batson violation that is not corrected at trial, there will be no retrial of the defendant, just based upon our supervisory authority over the court system?
You have the authority to do that?
And then, of course, we wouldn't be diluting or in any way, shape, or form affecting our double jeopardy jurisprudence, but we will be attacking the heart of this problem of racial, ethnic bias in jury selection. I don't know if that's a good idea or if you have some other thoughts, but I mean, sooner or later, after 130 years, there has to be a way to just bring an end to this.
Your Honor, you are the Supreme Court of Pennsylvania, and if you decide to do that, you can do that. I would suggest that this is not the case in which you're to do that, and that there are other ways that society is looking to redress social inequities and racial inequities. I cannot challenge this.
Justice Donahue suggests would be that we send it to the Criminal Rules Committee. That's the way we exercise our powers, and that gives everybody the opportunity to consider it carefully and to get public comment on it. And that gets you off the hook in this case. So we'll see how it goes.
Right. Well, at the risk of losing your vote, and I hope that I get some laughs from that, because you see the other side of my position, and you see the weaknesses in what I'm saying, I don't think that's a proportionate remedy to what's going on here. I just don't think that...
There are so few Batson violations over the course of the years. Is that what you're saying? I mean, I would understand that if that's what you're saying. That is the flip side of this issue.
No, I think that Batson violations are serious. They need to be taken into account. They need to be punished severely. I suggest to you that in this case, there are certain unusual circumstances that make this one a little less like the kind of case where you would want to pronounce what I've suggested might be appropriate in Flowers versus Mississippi, a sweeping rule that says one size fits all, and if it's a Batson violation, that's the end of the case. And I do think, while I am not free to challenge the Batson violation, I am not, Your Honors are looking at a situation where the finding here was by the Superior Court, and where I think, Justice Mundy, you talked about what a juror, and Justice Donahue, I think you were on board with this as well. What do you learn non-verbally from a juror? You learn from their body posture. You learn from their language. Justice Donahue, what else could the prosecutor have done beyond a certain point when 38 jurors were questioned in 51 pages of manuscript?
See, you had a really good possibility on a petition for allowance of appeal, but the beauty of this record, as I see it, is we have a fixed record. There is a Batson violation.
That's right.
Period.
That's right.
Period.
That's
I
right.
mean,
And
what would have happened if you filed a petition for allowance of appeal is a question for another day. But,
Or for no day.
Or for
because
no
they-
day. Yeah. The next time it happens exactly this way, then maybe somebody would file a petition for allowance of appeal. But that is in part the beauty of this case. We have a fixed decision that there was a Batson violation, which by definition is an intentional act on the part of the prosecutor. That's why this is a good case to look at this issue.
And that leaves me with the stated aliquotter question. Do the reasoning and rationale of Kareem Johnson dictate double jeopardy relief here? And I suggest that the reasoning and rationale of Kareem Johnson encompass more than just the individual defendant's rights, which are important and which were violated here.
Good argument, both sides.
Thank you. Let me just say to you, just in wrapping it up, I speak only for myself, it's greater than Batson, it's prosecutorial misconduct, which seems to always push the envelope, and the prosecution hopes it doesn't break it, and even if it breaks it, that they just have to do it again. But we'll consider that in this case in supervisory powers. You did a fine job, both of you, and we will conclude what's been a long day.
Thank you. It was a good argument, both sides.